and ask only for the time that you need to make your most important arguments. Understand that we have your briefs, we have the record, we're fully familiar with the facts of the case. So, People versus Shaquille White. Submitted. Trinity M. Submitted. Cook versus Hudson River Trust. 6, 2, and 6. Lman versus Consolidated Evidence, Edison Company.
Good afternoon. Request 6 and 2. Respondent request
6, 2, and 6. Davidoff, Hutcher, and Cintron versus McClendon. Appellant goes first. And no rebuttal? Are you the respondent or who's the appellant?
I'm Dept.
Okay. I'll give you 5 and 1. 5, 1, and 5. People versus DH. Submitted. People versus William Lee. Seven, 2, and 7. NRDGP versus McCarthy.
Appellant requests 8 and 4.
7, 2, and 7. People versus Luis Parada. Submitted. Glowats versus the City of New York.
Appellant requests
3, 2, and 3. SA Children is submitted. Island Consolidated versus Graci and Company.
Appellant requests 5 and 3.
5, 2, and 6. Veloso versus Catura Brothers.
Appellant, Your Honor, request 6 and 2. Respondent requests 4, please.
5, 1, and 4. People versus Jonathan Arzu. Submitted. Kohley versus Tari. We have 2 cases.
Appellant requests 25 minutes if possible. Respondent requests 5 minutes on each.
We're doing them all together. I mean,
And 7 minutes.
7, 2, 7, and 2. Altman versus New York City Department of Education.
Appellant requests 5 and 2. Respondent requests 4 minutes.
5, 1, and 4. Ada versus 450 West 31st owners.
Appellant requests 5 and 2, Your Honor. 5 minutes for respondent.
5, 2, and 5. People versus Ron Francis. Submitted. SJI Renewable Energy versus REV. Submitted. First case for argument is Cook versus Hudson River Park Trust.
Good afternoon, Your Honors. May it please the Court, Ian Sinclair with the New York City Law Department for appellants. Supreme Court incorrectly denied the city's motion for summary judgment. Plaintiff's basic argument is that the city and not the state designed the simultaneous green lights for right-turning vehicles and cyclists passing through the intersection that allegedly caused the crash. but both state law, the contract, and the record unambiguously demonstrate that the city had no authority.
What about the testimony of the witnesses?
So the Silver Brief references Ibrahim and Dorset saying that the city was solely responsible for phasing traffic signals. Patel said that all the traffic signals required the approval of the city. But when you look at the record sites, SR 144, SR 435.
But doesn't Patel say that the signal timing was controlled by the city?
Patel references that, yes. But
So that doesn't create an issue of fact?
it doesn't, because the signal timing is not what's at issue. The core allegation is that the lights were green at the same time. And plaintiff's expert explains what this
What's
means.
responsible for lights being green at the same time? Is that not signal?
Well,
Not the signal
there's the physical
control?
signal itself.
And the controls of that signal?
Yes. So there's the physical signal itself, and then there's computer programming that says what it should do when. The design, it says what the programming should do. So the design says we're going to have green
The
lights.
design and the phasing of the traffic of those signals?
Yes. So as we explained in the brief, and as plaintiff's expert explains, the issue is that the vehicle traffic, this is on R5 record site 582, the vehicle traffic signal and the bicycle traffic signal were in phase, i.e., when the signal was green for west-southbound traffic, it was green for the bicycle.
Counsel, how do you explain Chin's testimony? I believe he's was a city DOT employee, and his testimony, was that the design, the maintenance, and the repair of the traffic control signals was under the city's jurisdiction. So how do we explain that testimony?
I don't think we're disclaiming that the city has maintenance jurisdiction. There's the maintenance agreement sets forth what the
But
city's
what about the approval of the design? Once the design is done, there's the approval. So the city has approval over those designs, right?
So what Albany's makes clear is that Article 12B and the approval power under subdivision 3.4 of 349-C does not by itself create design veto power. Plaintiffs in Albany's made the exact same argument that the city, that in that case, that the city reviewed the plans, that it inspected the site, and that it, under section 3.4. And the Court of Appeals found that that was not sufficient, that where the project, just like here, is the state's, where the state had the state hired they solicited the bids, they hired the design contractor, they oversaw design, and they fielded design changes throughout the construction process, that was what mattered. It was a state project, and the city did not have a substantive role in the design.
What about the fact that the city, had to approve the plans? What about that?
That's exactly the same facts as in Albany's. The plaintiffs made the exact same argument that the city reviewed plans and issued building permits, and even had unilateral authority to revoke those building permits. But that wasn't sufficient because it wasn't that the general approval power under 3.4 is not the same as the design authority under subdivision 3.2 and 349C. These are distinct powers, and the Article 12B of the highway law is crystal clear that design authority goes to the state unless the state specifically authorizes that to the city. And here, the only specific authorization between the state and the city is in the maintenance agreement. And the maintenance agreement is clear that the city is prohibited from, the obligation of the city is to implement the traffic control signals as designed, and is prohibited from making changes. I'm sorry.
No.
Oh, sorry, I thought you were raising your hand.
The city cannot at any time change the timing or the phasing of the traffic light? It's got to wait for the state to do so?
Yes, that is what the maintenance agreement says.
And in practice, how does it work? Exactly as the agreement says, or according to the witnesses, the city in practice changed the phasing and the timing?
When the city changed the split phase that occurred roughly 2 to 3 months after, the only person who worked on that said that they approved, they pitched this project to the state, and the state consented to it. Even later after the 2019 study, which respondents focus on,
The state has primary responsibility, but the city has a role in it too. Would that primary responsibility of the state absolve the city so that it could obtain summary judgment here?
In this instance, it
I mean,
should.
what if you're both responsible?
Well-
The state is more responsible, but you're also responsible.
Article 12B does not contemplate concurrent design jurisdiction. And that's really what we're focused on, is that the initial design was set by the state, that they, as the witnesses said, the timing, the designers design the timing, they give that, the contractor takes that timing, they insert it into the controller, and then the city programs that timing in accordance with the contract. That's exactly what they say.
Isn't it true that Patel reviewed the design prior to it going to a contract? It had to be approved by Patel?
Well, Patel, I think, is with the state. But, so he certainly did, yes. He oversaw general construction. And in that regard, he absolutely reviewed all the contract documents.
Thank you.
Thank you.
Daniel Flanzig for the respondent, Olga Cook, and her husband, Travis Cook. As you know, this is a tragic case of a 30-year-old young lady who lost her life.
Yes, you said we do know.
Okay,
So why don't you get to the heart of the matter?
absolutely, Your Honor. Look, I think the court understands the arguments here, what has been raised. There's no issue of fact that the city of New York controlled these traffic lights.
Didn't the city only receive control over the roadway signs 9 days before the accident?
No, Your Honor, the maintenance agreement was signed 9 days prior. The city was called out to program the lights in 2015, almost 1 year prior to the actual turnover of the agreement itself. There's no issue.
The agreement only took place 9 days before the accident.
Yes, but their affirmative act of programming occurred almost a year prior. And it has also been under their jurisdiction, not since 2015, but since the two designs of this roadway, one occurring in 2005, and then the second one that began, then came to a stop during 9/11, and was now part of the second process. The city has always maintained the timing and controlling of that light. The maintenance agreement is just the renewal of the understanding as to what their obligations are going forward. But prior to the accident, this has always been under the jurisdiction of the city. They were called out in 2015 by the state when the state delivered to them the traffic lights. I use the analogy of almost a car being given to a driver, and you could pick out your color and you could pick out your type of car, in 4-door or 2-door, and the state delivered to the city the car that they ordered. The city was involved in the process in choosing the color and everything about it. And now it's upon the city to drive that car properly. Just because it can go 100 miles an hour as designed by the state doesn't mean you drive it.
What about the argument that the highway law, Article 12B, relieved them of their duty?
I don't believe either the Court of Appeals in Nolan or this court in Gregorio ever said that to a fact. And this is something different. This is something that involves two issues that are different in Nolan and Gregorio. Number one, this involves not just the West Side Highway, it also involves Chambers Street. So the city of New York has an obligation to control the streets within its jurisdiction. This is also different as Nolan and Gregorio because this is an affirmative act. They had an obligation to time the lights in accordance with the MUTCD standards. In 2015, the MUTCD standards, of which they offer no expert opinion that their timing complied with, required them to eliminate the conflict that existed. Nowhere in Gregorio and Nolan are distinguishable, or actually binding here, because those, this is an affirmative act, is what my point is.
Did Dorset of the city testify that the city would determine whether there should be a change in signal timing or phasing?
No one has really, this is something that was raised for the first time on appeal. The term that was used throughout all these experts is programming. You cannot have phasing and timing. They are interchangeable. By example, if I set up a phase to make a left turn, and I make that phase for that timing for 1 second, they don't work that way. You need to do both together in order to have a safe intersection. And there's not one person who ever distinguished phasing from timing. They used the term programming. That box we talked about, that controller, has two settings, phasing and timing. They are interchangeable, and once the state called the city out to conduct that timing, they did both. They did the phasing and timing because it makes no sense to do one without the other. And also, they need to control two streets, Chambers and the West Side Highway.
That traffic signal at that intersection, how long had it been there?
It had been in existence at least since 2005.
With the same phasing and timing?
Same, yes. The only time it changed is 60 days post-accident. That's how easy it was to remedy this condition. And after this accident, after this tragic crash, they then continued, the city alone, not the state, continued to address the rest of the intersections along this corridor.
And since 2006, when that traffic light was first installed, who maintained, controlled, and did the phasing and the timing for that intersection?
The city of New York, it's always been under their jurisdiction since before the accident and even after the accident.
And is this something that the witnesses testified to?
Absolutely. All the city witnesses testified, all the state witnesses testified that this is the city's responsibility. In fact, one of the testimony was, I am 100% sure this is the city's responsibility.
I think that was Chin.
Yes. That's the language he used.
Thank you.
Thank you.
Just to pick up on that last point, because you asked about Chin, and I don't think I answered. So Chin his role is limited to maintenance. And again, we're not contesting that the city has maintenance jurisdiction through the maintenance agreement. But Chin has no specific knowledge of this project. He is asked point blank, do you know anything about the West Side Highway or the reconstruction project? And he says, no, I do not. So he cannot personally testify to the city's obligations or duties, much less signal timing and phasing, which is outside of his unit. To the point about Gregorio and Nolan, Gregorio relied on quite broad language that's in Nolan that Albany's significantly curtailed. Nolan had been read as to essentially contemplate concurrent jurisdiction, and Albany squarely put to rest that that is not the case, that there is a sequence of back and forth between city and state control, and that the state holds maintenance jurisdiction and can delegate that jurisdiction in accordance with the statute. That's exactly what happened here. The state held design authority, it contracted with the designer and with the construction contractors, and it delegated only certain maintenance duties to the state, to the city.
Counsel, is it true between 2010 to 2014, there were similar accidents at the subject location?
There is evidence in the record about different numbers of crashes. Our position, which we point out in 27 to 31 of our brief, is that—
Wasn't it the same situation and the takeover by the state when they did the changeover? The testimony was that nothing really changed. They just handed it over back to the city. There were accidents from 2010 to 2014, and then fast forward, we have the subject accident.
Well, as we argue in our brief, that the number of crashes or their similarity doesn't really change the fact that the city couldn't have done anything about it, because throughout the design process, the state was in charge of the project.
Why didn't you do anything before the state process?
Before 2006?
Yeah. No, but from 2010 to 2014.
That was part of the state's project. The project ran from 2006 or 2007 to June 2nd, 2016. That's when the contract was accepted. So that's the formal end of the project.
Sorry.
Thank you.
Thank you.
Thank you both. Lman versus Consolidated Edison.
Good afternoon. May it please the court, Sim Shapiro on behalf of third-party defendant appellant Nelson Services. The issue on this appeal is not whether the conduct by Con Edison's counsel happened. He acknowledged that it happened. The issue here is not whether it's improper. I think it's very clear, and the court below actually said so at oral argument, whether that was improper to have communications with a represented party, specifically with regard to the litigation. In fact, the document was called confidential letter.
My question, it's to what you're about to say. I'm asking, what is privileged or confidential about this agreement?
It's our position that it's not confidential. If the issue for the court, if Your Honor is asking, why was it the subject of a motion?
No, it doesn't seem. I'm curious because the argument was it's confidential and it's privileged, and I don't see anything in it that's necessarily confidential or privileged. I'm curious.
I don't either, Your Honor.
Whether you can point that out for me, one of you.
I do not. I voluntarily did not file it on NICEF in the abundance of caution. There was no request for it to be filed not on NICEF. There was no order. There was no sealing order. We did it since it was labeled as confidential. The entity that prepared that was Con Edison, so they may have a different answer to that question than I do. But it's our position that it's not necessarily confidential and in fact is a subject of this appeal. But since they labeled it in the abundance of caution, we did not file it on NICEF, at least not initially. It is now there because it's the subject of a motion. So in any case, the issue here on this appeal is what is the appropriate relief when this conduct clearly happened and was clearly improper? It's our position that in fact, if this is so egregious that the third-party complaint should be stricken, or at least the claim for contractual indemnity, which is the remaining claim, or alternatively, the voiding of this agreement, which was clearly done, as Your Honor can see on the emails, clearly done under duress, with very specific language that it could impact the renewal of the agreement. That's on pages 63 and 64 of the record on appeal. So respectfully, although the court below was sympathetic and certainly was not approving, and Justice Krauss pretty strongly worded in her condemnation of the conduct, at the end of the day, Justice Krauss did not order any relief under the premise that it was, in her view, intended to delay the trial. In fact, it's our position that was not. In fact, we withdrew the request for a stay. We'd only requested it because—
Counsel, isn't it true that the confidential agreement included a provision which stated that Nelson had the opportunity to have counsel?
It included that provision, but that does not make it acceptable. It could say whatever it says. It doesn't make it acceptable, and especially—
Wasn't one of your arguments that Nelson did not have the ability to have counsel, and therefore it was unconscionable going through that argument? And you made many arguments. It wasn't one of those arguments that counsel was not present, so it was unfair, essentially.
The argument was that it was improper to reach out, even if they say to the individual as a principal of the company who's not an attorney, and I do thank my clients actually here today, Mr. Gisbert. So the fact of the matter is, just because you say, by the way, you could have counsel, the Rule 4.2 is very clear, and in fact, the comments are very clear. You must include counsel, whether or not you tell them, hey, by the way, you could have counsel here if you want, or you should show it to your counsel. When we have an agreement concerning litigation, there's no exception to not contact the attorney. And I might add, the argument, which frankly had held no weight anyway, that, oh, we thought they had a conflict of interest.
Can I read you what it says? It actually says,
Yes.
paragraph 8, that it has been represented by and has consulted with the counsel of its choice regarding the provisions, obligation, rights, risks, and legal effects of this letter agreement. So it didn't say that you had the opportunity. It said that you actually consulted with counsel.
There's nothing in Rule 4.2 that says that that's sufficient, that if you put that language in, and again, you're having somebody reading it who's not an attorney or may not understand all that that means. And the reason for the rule, there's no exception for that in the rule. And the reason for the rule is so we don't have a situation like we have here right now, which is, in fact, counsel, me, had no knowledge of it, and there's no disagreement about that. And unless the court has any additional questions, I'll address any other issues in the rebuttal.
Good afternoon, Your Honors. Patrick Brophy on behalf of Con Ed. The first thing about 4.2 is that it has to be about the subject matter of the representation in order to be a violation of the rule. We would submit that when the court looks at the actual facts, Mr. McNulty's contacts with Nelson Gisbert were not about the subject matter of the representation. This agreement, its heading notwithstanding, did not concern the future of the Lman litigation. It concerned the fallout from it in a 40-year business relationship where for the second time, Nelson had left Con Ed with an uninsured liability. And so for the second time in the history of their relationship, it happened
Counsel, does that really excuse that conduct when counsel specifically for Nelson said that it is representing Nelson and it should be and he should be contacted?
I think it would have been ideal if the contacts between Con Ed and Nelson had been entirely between operations personnel. And as Your Honors can see, if one looks at the record between pages 92 and 97, there was a great deal of contact between the operations personnel at Con Ed and Nelson Gisbert that did not involve Mr. McNulty or other Con Ed legal people. What happened here, it's not that Con Ed was threatening.
Sorry, I think that's the key. It didn't involve other legal people. The lawyer, the lead lawyer on this case.
Oh, no, well, it did also involve Mr. Soto. Mr. Soto was addressed along with Mr. Shapiro on one of the early emails, and then Nelson Gisbert wrote to Wayman Sanchez, an operations person at Con Ed, that my counsel can be available tomorrow, April 3rd, between 1 and 2, which was the time of the Teams call, that Mr. McNulty testified that Mr. Soto was on. Again, 4.2's focus is the subject matter of the representation, specifically the subject matter of Mr. Shapiro's representation. Again, this was not about the subject matter of the representation. Rationally, it couldn't be, because Nelson had already lost as much as one can lose, and Con Ed had already won as much as one can win the Kinney claim for Nelson's failure to procure insurance as promised in the contract. That was done. It was adjudicated through this court to finality. What remained was, essentially the legal question of indemnification, which operates to Nelson's advantage, because if we didn't have the confidential letter agreement, here's what we've got. We've got Con Ed waiting to enter a judgment for immediate satisfaction, running 9% interest in the event that's not immediately satisfied against one of its vendors. What we have instead, and that's assuming that Con Ed loses all the way with what's left on the contractual indemnification claim. What we have instead is an agreement that is not unconscionable at all. It gives a valued vendor years to pay the liability that it incurred to Con Ed, that this court's already passed judgment on, only to the extent of $5,000 a month plus 5% of gross revenues,
it was
only from Con
$10,000
Ed,
a month,
only
but-
under this contract.
I thought it was 10,000, but that's a small point.
It depends on how far out you are. And only above a threshold of $215,000 a month or $235,000 a month, depending on how far out you are. And this was after.
Well, what would be if that agreement did have confidential information? And what should happen then?
I'm not entirely sure that I understand Your Honor's question. Paragraph 4 of the agreement states that it's confidential, as does its heading.
Yes, but if it contained if the confidential letter agreement contained information which was confidential in terms of attorney-client relationship.
No, I don't believe that it did. It
What
concerned
if it
confidential
did?
business information between Con Ed and Nelson. I'm sure that Con Ed doesn't really want, Nelson probably doesn't either, the world to get into the details of its private business. The world has no need to be into this. But it doesn't say, oh, there's for example, counsel was arguing from the Lman case and the Shaw versus Elton case. I mean, those cases were remarkable. I mean, those are destined for the law school case books because their facts are so outrageous. If you're familiar with Lman, that was a litigant helping herself to the contents of adversary counsel's file in a courtroom while he was busy. And Shaw versus Elting was an extraordinary stream of emotionally disturbed theft of the adversary's personal emails, computer drives, et cetera, et cetera, et cetera, all during ongoing litigation. There was no, McNulty testified, there was no discussion of the substance of the matter of this representation. There was a discussion of a payment plan for the fallout from Nelson having let Con Ed down for the second time, and there was discussion of a completely unrelated minimum wage agreement that had nothing to do with any of this.
Thank you.
Okay.
Good afternoon again. 2 points I want to correct. The premise that personal counsel was involved, in fact, my client stated very explicitly in his affidavit his personal counsel was not involved and was not sent a copy of the agreement. So that's first of all. Second of all, the idea that my client had already lost, we wouldn't be here if that was the case, because the whole premise of all this is to continue the contractual indemnity claim. And in fact, that in that confidential agreement, the one that's supposedly not really about the Lman litigation, if you look on the bottom of page 2, just to read you one clause, it says, this letter agreement shall not constitute a waiver, release, compromise, or discharge of any claim, suit, cause of action, or right of any nature whatsoever that Con Edison may have against Nelson or any other person, partnership, or corporation with respect to the Lman accident. So the whole premise of this is that they're in fact continuing the contractual indemnity claim, so it's not already completed.
Wasn't it already determined that you breached the contract by not having insurance?
My client, yes.
Okay, so now the only thing remaining is the personal injury action against Con Ed.
Actually, that's been resolved. It's to whore the record, but
Well, it's
counsel did
door
put
the
that-
record, but the point is, at the point where this letter was sent,
Yes,
it was already clear that your client hadn't procured any insurance on this
absolutely.
issue.
And what this document does, it permits them to continue to pursue the contractual indemnity claim. And that's actually why, that's the only part of the case that is in fact still going. And that's the whole basis for this appeal. Because in fact, this agreement that they signed actually permits them to continue their contractual indemnity claim against my client. So in fact, it's not just the fallout from the litigation, it's continuing that litigation and is quite explicit.
Wouldn't they have been able to do that anyway?
I'm sorry?
Wouldn't they have been able to do that anyway?
Actually, if I'd been involved, they wouldn't have been because
Were
the
you
idea
involved?
of saying, I'm sorry, I was.
You're saying if you were, the letter had been sent to you,
If I'd been notified, the idea of saying, we're going to have an agreement in which you agree to pay up to $5 million, but we get to continue.
even if they
every aspect
didn't
of this
sign
claim.
that, even if they didn't sign that, wouldn't have this have been continued anyway?
But this has both, Your Honor. In fact, if they hadn't signed it, that would be something else. And in fact, one of the points of relief that I'm asking for is to void the agreement to get them back to square one. But the idea here is we get to have the best of both worlds. Yes, you're paying us back up to $5 million, but no claim is extinguished. There's not even a provision here for a general release.
But how can you seek to, how can you seek to void the agreement when you didn't, seek that relief below?
I did seek that relief below. It was part of the relief that I sought in the order to show cause in the court below.
Thank you. Thank you both.
Thank you.
Davidoff, Hutcher, and Cintron versus McLendon. Sorry.
Good afternoon, Your Honor. May it
afternoon.
please the court. I appear here for the plaintiff. The main issue here, Your Honor, has to do with legal bills. And
Well, it is an attorney's fees action, but your client defaulted on the summary judgment motion, and no appeal lies from a default. Even if we assume for the sake of argument that you have an excusable default, what meritorious defenses do you have? And, this argument could arguably be that could be meritorious. Where is that?
couple of them, Your Honor. The first one was the plaintiff in this case actually overbilled my clients.
Isn't that all in your reply? Aren't all these arguments in your reply papers?
They are, Your Honor.
But they have to be in your main brief. You can't be in your reply papers because then the other side doesn't get to respond to it. The first time they're raised can't be in the reply.
That's what the court below concluded. But the reality of the case, Your Honor, is that the court, as well as the plaintiff, actually admitted that my client was overbilled. And that was why the court refused their motion to dismiss initially. The plaintiff
Is
went
that
back.
in the main brief? Are those arguments in the main brief?
Those arguments were there. The plaintiff did go back and corrected.
They filed an amended complaint, didn't they, which
Yes,
corrected
yes.
which
They went
corrected
back.
those. Yes.
They did. They went back, but they did not correct all of it. There was at least one attorney whose overbilling continued. And apart from that, there were agreement and understanding that the plaintiff agreed to that was never implemented. And they included the agreement to waive or write off $61,000 and also to give my client some discount. These were never implemented. And we never really-
Question for you. So with the motion to vacate, when the motion was made, I believe some in substance that, the bills were inaccurate because the amount charged was inconsistent with what was agreed upon, right?
That's correct, Your Honor.
Okay, so my question is, were there any documents attached to the motion to show, what's being charged? The invoices certainly don't, match up. There's an inconsistency. Was there anything in writing besides the affirmation?
I believe the retainer itself was attached, and the plaintiff did not dispute this particular fact. Their only position was, say, we filed an amended complaint and we corrected that. But the reality is they did not correct.
Because the reason why I'm asking you that is because, from my understanding, from what I remember, it was just the affirmation. It was very vague, very conclusory, no documents, and as, the presiding justice indicated, it was only, in the reply when much more detailed was mentioned, which is really improper for a reply.
I think Your Honor is correct on that point, but in that affirmation, I did reference the court decision of April 17, 2024, where the court actually declined to entertain his motion to dismiss, given the fact that he admitted there were billing errors. And I thought that that in itself establishes meritorious defense.
Is that it? Thank you.
Good afternoon. Joseph Polito, Davidoff, Hutcher, and Cintron for the respondent. Just to correct the record, even though it's not necessarily on the appeal, the motion to dismiss the counterclaims was granted. There were two counterclaims. The first was for breach of fiduciary duty. That was dismissed. The second counterclaim was overbilling, and that was converted to an affirmative defense. And at that time, Davidoff and Hutcher and Cintron said that they would be amending the complaint to address two billing issues. The amended complaint was filed. After the amended complaint, motion for summary judgment was filed, attaching the readjusted bills. Defendant defaulted. The issue here is that everything that is alleged as being still an existing overbilling was only supplied on reply. Outside of the attorney affirmation and the decision and order regarding the motion to dismiss brought by plaintiff, there was no evidentiary facts with regards to any meritorious defense. It was just, I believe, one conclusory allegation in the affirmation that there was some overbilling. You cannot wait and put everything in a reply. The trial court recognized that. There was no abuse of discretion with regards to CPLR 5015A. Therefore, the order should remain. Unless there are any questions, respond.
Thank you. You have 1 minute rebuttal if you want it.
Thank you, Your Honor. I'd just like the court to also take cognizance of the fact that both decisions issued by the judge in this case did not include one citation. So it's really hard for us to actually fashion an appropriate response, at least, that will have addressed what the court was concerned about. I just wanted to make a note of that.
Thank you. Thank you both. People versus William Lee.
May it please the court, Beth Fish Cohen for the people. The prosecution exercised due diligence and made substantial efforts to comply with their discovery obligations.
Counsel, I'd like you to focus on the 3030 issue. The judge, really, why wasn't the judge below correct in its decision to exclude those 29 days or whatever they were from the charge, from the counting of the time? Or not exclude them, but include them, rather.
So under Barden and other cases citing Barden, when the defense asks for more time than the people do, that time is not chargeable to the people, even in a pre-readiness posture.
But in Barton, first, the facts were a little different than this one, because there's an attorney who is asking for an adjournment for a different client in a different case in a different forum. Here, there is a question about the DNA, and there is a suggestion that the time that's been requested, first of all, the case has been going on for some time, and then it's obviously the prerogative of the office to then decide to do the DNA a year or a year and a half, whatever it was after it. But at that point, the attorney asks for a period of time that seems completely unrealistic, and we know it was unrealistic because it didn't even come close to the time. And the person is told that. The defense says there's no way, that time is just not. And there's something in the record that suggests, I'm not going to be able to find it now, but the response is, yeah, but I'm going to pick that date, something like that. But in any way, it's clear that everybody seems to know that that time is unrealistic. And the defense attorney has to pick a date because there's a trial. I mean, the date that the DA picked for trial, the documents weren't even returned by then.
So when the prosecutor asked for a 1-month adjournment, defense counsel agreed that it would take at least 3 to 4 weeks to receive the DNA results.
Except
so that
the
does not.
question that was, she asked for an adjournment for trial. She didn't just ask for an adjournment for the return of the results. She asked for an adjournment for trial. She was assuming, I guess, that those results would have come back in 2 weeks, which is why the response was made that's going to take at least 4 weeks. So where was the time that was, unless your office just gets DNA results and goes to trial the same day, which I don't think is the case. I think you take time to prepare it. Where was that time built in there if she asked for 4 weeks for trial? Where was that DNA time coming in there? And I ask these questions because I'm concerned that this kind of practice of asking for a time that is clearly not enough for what is necessary, and proved that in this case, that it leads to gamesmanship or manipulation or anything else Yeah.
So I have a few responses. First of all, Barden and the progeny is not limited to other cases where someone says, I need time for an additional case. There was no accusation below of gamesmanship. There was not part of the record at all. So there's no indication here that this was this unrealistic expectation. Mind you, the defense here is consent. So the DNA, this is not something that is so out of the realm of that they couldn't go to trial quickly. I recognize that the court does not agree with this request, but I do think this falls neatly within Barden, but we would still hope that this court will turn to the due diligence analysis as that is there. Every other department has had numerous cases interpreting Bay, and I think that it would be great if we could get a ruling from this court on what we perceive to be a violation of Bay in this case.
I'd just like to follow up with the presiding justice's question, because, you talk about Barden, and, certainly in Barden, there was the long adjournment date for defense counsel's scheduling. And what the defendant is saying, and I'd like you to address it, is that this was caused because, number one, the people, for whatever reason, decided not to conduct DNA testing, then, later on, changed its mind, then provided a date which not only the court, but defense counsel said, I'm not sure, it's a bit unrealistic. And so what they seem to be arguing is that this was caused by the people's actions rather than anything that defense counsel consented to. It's a little different. So how do you address that?
The way I address that is that the earlier time period had already been charged to the people. So the people recognized that whatever delay they had in requesting the DNA results was already accounted for. But once they already were charged for the earlier adjournment, they should not be charged afterward.
What are you talking about afterwards and before? You're talking about any period earlier than those 29 days? Is that what you're talking about?
Yes, so earlier,
And that is my point. While nobody alleged gamesmanship, that is exactly what this can lead to. I don't know whether it was deliberate or naive, but asking for a date that was impossible to meet. In fact, it was 4 weeks, I think, or more than 4 weeks when the date came up, and the results had only been received 10 days earlier, and the people still weren't ready on that date and weren't ready for another month, I think, thereafter. So I'm not really sure when you talk about that period, what you're saying there.
so prior to this time frame, normally under 3034G, the people, when they exercise due diligence, can have a lengthy period of time excluded for DNA results as an under the exceptional circumstance provision. Here, based on the fact that we hadn't asked for the DNA results earlier, we conceded that some of that time was chargeable to us. But I don't think that affects the time after that in which...
Well, I understand. That's the argument here. That's that one's obvious. I thought you were arguing something different. Okay. Thank you.
So the
I
situation is on May 17th, the people ask for June 13th to do the DNA testing. The defense counsel says well, it's going to take 3 to 4 weeks, so it's put over to July 12th, and defense counsel is charged from June 13th to July 12th. And on July 12th, the people are not ready because you received the DNA results 10 days before. I would take it that means you received it
July 2nd.
10th. So who gets charged with the fact that now as things turn out, the DNA results weren't ready on time? How does that figure into 3030 computation?
I don't think that is relevant because there was no indication below, contrary to what is being said, that this was being asked for in bad faith. So it just does not, motions take longer than we anticipate. We don't turn back the clock and say
Well, you start getting charged again on July 12th, right? Because you're not ready on July 12th. But when it turns out that you're not ready, so the defense has already been charged from June 13th to July 12th, which, as it turns out, the reason that the DNA results are not ready within that time frame, not until July 10th. Do the people then, well, now we look back at this and say, well, the defense shouldn't have been charged from June 13th to July 12th because the people weren't ready until July 2nd, until July 2nd anyhow. Is that the way this is approached?
I believe under the case law that time frame that was requested was not
Once
chargeable.
it's done, or do we afterwards look back and say no?
No, unless, in this case, this court has held there are times when if a request is made in bad faith, then that is different. But there is no indication it was made in bad faith. There are times when things take longer than they are, and we don't.
What's the average amount of time that it takes in a DNA? This was a simple case. He had already admitted on a telephone call that I'm the guy. So it wasn't really likely or expected that it would come up with somebody else's DNA. So, I mean, what is the average amount of time that one expects to get these results?
Your Honor, I'm not in a position to say that. But what I can say is that I do not believe this is gamesmanship. What I believe was at issue here is that because it was viewed as a consensual relationship, the prosecutor did not feel the need to request DNA and ultimately change that.
And let me just make clear on this gamesmanship. It may not be in this record, or it may not be said, nobody's saying that, but this is the very kind of thing that one has to be cautious of, because it could very well be that this encourages this kind of thing. That is what I am saying. On this record, it certainly could be. I'm not saying it is, I'm not saying anybody accused it, but that is exactly the kind of thing that one has to be wary of. Anyway, thank you.
Okay, will I be able to turn to the other argument in rebuttal since I didn't?
Of course, you can deal with whatever you'd like in rebuttal. Technically, you respond, but I will allow you, just so you're clear.
That's the reason I asked, Your Honor.
Yes.
May it please the court, I am Andrea Zellen, and I represent the defendant respondent in this matter, Mr. William Lee. I'd like to pick up, Your Honor, where you left off with respect to the speedy trial argument. I'm glad it came up. In the course of preparing for oral argument, it came to my attention that there is, in Justice Lantry's decision, a calculation error. And it's a calculation error in which he calculates the period of time from May 17th through July 29th as 56 days. I believe Justice Lantry intended to charge the entire period, which is 72 days, to the people. Why is this important? If I'm correct, and there's a calculation error, even if you grant the people's motion and agree with their position regarding Barden, they are still over. Because when you add the 16 days that Justice Lantry didn't include in his final number, it's 188 days, and they are over the speedy trial limit for a felony prosecution. If you like, I believe our arguments regarding Barden are strong in our papers. I can address any questions the court has with respect to Barden and the speedy trial.
Just going over so on May 17th, the people asked for June 13th, which is slightly less than a month. Defense counsel responds that it would take at least 3 to 4 weeks. So that time frame is within the time frame that defense counsel says is necessary. It's very close. I mean, maybe it's a day or two off, but it's as close to what even defense counsel says is the time period. And then defense counsel requests July 12th. So what is the infirmity? Yes, it's very close, but it is the June 13th date is within even the time frame that the defense counsel set forth. What is the infirmity in then saying on May 17th that the period of June 13th to July 12th is charged to the defense? Or do you say that comes July 12th, the people are not ready, so we go back and have to recalculate the fact that that the defense was going to be charged from June 13th to July 12th?
I'm going to try to answer your question, Your Honor, and if I'm not understanding, please stop me. But our position is that the adjournment from May 17th to June 12th is chargeable to the people, and I believe the people concede that point.
Yeah, isn't that what happened?
Yes, and then thereafter, when they request that date, I believe the prosecutor at that time says that he believes defense counsel is going to ask for a later date. And I, in fact, defense counsel did, in fact, request a later date based on the fact that defense counsel believed it would be 3 to 4 weeks minimum for OCME to produce what they needed to produce to the prosecutor, and so that June 12th would not provide sufficient opportunity if they even met that date.
But is that's part of my question. Isn't that date within the time frame, May 17th to June 13th, is pretty close to the time frame that defense counsel says is necessary for this to come back?
I will concede that that is the similar time period.
But those 4 weeks, the prosecutor asked for a period of time that included the time to get it back and be ready for trial. That's what those 4 weeks were. Whereas the defense attorney was saying, it's not coming back for 4 weeks. Not that then there'll be that readiness for trial, which is why I asked the question, doesn't the prosecutor need any time after they receive the results to prepare for trial? Yes, 4 weeks is about the time that passed, but it wasn't simply to get the results. It was to be ready for trial. That was a trial date. It wasn't to have the results back.
That's correct, Your Honor. That is correct.
So then answering the question then, does that, if those 4 weeks were the ones that were chargeable, those 4 weeks to the prosecutor, but the documents didn't come back for another 2 weeks, I think, maybe more, after they didn't come back until July 2nd. So the question really is that time period?
Chargeable to the people.
Yes, to the time.
Yes, it absolutely is. And I'll also point out, Your Honor, that
But isn't it defense counsel who says that defense counsel would need some period of time to review?
yes, yes,
It's not that the people will need, it's defense counsel will need.
correct, Your Honor. But the reason I needed any time at all, Your Honor, is precipitated by the district attorney's decision, which is within their rights, to continue their investigation and to conduct DNA testing.
In other words, when you are relying on their time, I mean, you're relying on, I don't want to say lured in, it's not quite what I'm trying to say, but you are basing that time on the validity or the truth in the statement that they're making, that they do believe that is going to come on that date. And that's the date that you are basing your period of time on. When if that date is not realistic in any way, it doesn't seem, I'm just wondering whether or not that should be chargeable. It is in this instance on an ACME kind of, lab that one is relying on, whether or not 4 weeks, including being ready for trial, is at all even close to reality.
It's not close to reality.
And whether in that instance it should be not chargeable to the people, which I think they concede on one of the dates before the judge. I think not that anyone has to be bound by that when preparing papers.
The entire period, it's our position, the entire period of time from May 17th through July 29th. Why July 29th, Your Honor? Because that is when they actually meet their disclosure requirements and file their certificate of compliance, and that's when they file their statement of readiness. Almost 16 days after the July 12th date that defense counsel had requested.
Now, counsel, may I? When you started your argument, you said that the court had made a calculation error, that instead of charging 56 days, it should have charged 72 days.
Yes.
Are the people contesting that there were any other periods that the court should have excluded?
Not on appeal, Your Honor, and I believe the people have conceded that the 16 days I'm referencing that were not included in Judge Lantry's calculation are in fact includable and chargeable to the people.
So when you deduct the period that we've been discussing here, you would still be over the 183 days?
Yes, Your Honor.
By how many days?
By 5 days. My math came up with 188, Your Honor.
Thank you.
Thank you.
Thank you.
You have 2 minutes.
Thank you. The Supreme Court's dismissal of the rape indictment with a cooperative victim was contrary to the statutory scheme, seriously misapplied Bay, and also is in contrast to the persuasive decisions from the 3 other intermediate appellate courts. The holistic analysis required by Bay shows that the people timely provided voluminous and far more relevant disclosures, that the belatedly disclosed 1 or 2 text messages compared to the entirety of materials disclosed were
Counsel,
comparatively insignificant.
Assuming you're correct that we agree with 245.20, does that save you? Does that save the prosecution, notwithstanding the issue with the 30-30?
Yes, Your Honor, because there is far more time available if the court finds that the,
How much time would you have if 245.20 is found in your favor?
I'm sorry, there
Did you
were,
do the calculation?
I had done
I
the
didn't see it.
I'm sorry, I had done the calculation before. I was not prepared for that right now.
I'm sorry.
There were numerous. A reversal on the due diligence issue affects 3 different periods: May 17th to July 12th, October 20th to November 30th, and November 30th to February 21st, 2023. So if you look in my brief on page 41, I think you can.
So the
math
math
is there.
works out that it's less
The
than
math works
183
out,
days?
yes.
Okay,
And
thank you.
okay.
I know you want to discuss Bay, but I wondered what your response is to what defense counsel said about the 188 days.
I was not really prepared for a calculation error at this moment. We briefed this whole issue. I'm sorry, I was not expecting to come up here and recalculate time at this point.
I'll give you a few, oh, did you have, go ahead.
Yeah, the question was if you agreed with the defense that the only thing you're contesting is that 29 days right now.
Your Honor, we are here, the reason the people appealed this case is because we feel that the dismissal was in error. It misapplied the law. That what should have happened and has happened in numerous appellate courts across this state is that there's a recognition that based on a unanimous Court of Appeals decision in Bay, that we neither require nor anticipate perfection from the prosecutor. And here, that is exactly what happened. This is the type of result that led to the 2025 amendments. And we're not even asking this court
You're not
to
talking
apply
about
those.
30-30. Can we be clear? You're talking about.
I'm talking about due diligence, that this was an error because of the amount of material the people disclosed, their responsiveness to counsel, everything about this case, 15 pages of notes created by the prosecutor himself with information that led to more and more discovery being revealed. And the Supreme Court's decision was wrong in saying that it was constrained to reach this only possible remedy of dismissing and invalidating the COC. That is not correct. The court was fully entitled to say that the people exercise due diligence and then go to 24580 and impose a remedy or sanction. We would be fine with that. But that's not what happened below. The court did not apply the Bay factors in the sense that it hyper-focused on what it perceived to be the lack of an explanation, and I suggest to you that the reason that it was so focused on that, it was because it was the prosecutor's own phone. And I just will repeat to you that—
We don't need the repetition. We're familiar with the Bay factors and this case, and you'll have to wait and see what this department does.
Okay, thank you.
Thank you. Thank you both. NRDGP versus McCarthy. May begin.
May it please your honors, my name is John Brickman with the firm of McLaughlin and Stern, and I represent the appellants Nebula Research and Development Holdings LP and its general partner, NRDGP LLC. Now, we recognize the deferential review generally afforded to arbitration awards on appeal, but there are exceptions, and we urge strenuously that this is very much one of them, because here the arbitrator has rewritten the parties' agreement to say exactly the opposite of what the parties actually intended and provided.
So you're talking about 6.5C, I imagine?
Yes, Your Honor.
And so why is that not an interpretation with regard to the advancement? Why is this a complete rewriting? I mean, as you know, arbitrators have great leeway.
Because it's not an interpretation to say that the subsequent sentences of 6.5C are simply interpreted by the arbitrator. She stood them on their head. And what she did was to say, yes, instead of limiting those sections to to indemnity circumstances, namely third-party claims. I'll say that again because I mangled it. Instead of limiting those sentences to advancement circumstances, namely third-party claims, she included first-party claims and did exactly what the language of the...
Isn't it true that you didn't raise that argument below?
It was not raised in the arbitration,
Right.
but it was very much raised at Supreme Court when we moved to amend our petition, and Justice Kelly granted our request for leave to amend.
Isn't it true that the trial court is limited to the record below? If you didn't make the request before the arbitrator, isn't the Supreme Court not, it hoards the record and you can't make new claims that you didn't make before the arbitrator?
Well, number one, the respondent has not cross-appealed and raised that issue on appeal.
That's not the point. The point is that I thought that the record speaks for itself, and if it's not below, then it can't be raised here.
Well, Your Honor, I would disagree. There's a subspecies of circumstances. That is a smaller...
If it's a matter of law, you can raise it.
If it's totally a matter of law and it doesn't require the additional development of fact, you can raise it in this room. And that's, I would urge upon Your Honor, exactly the circumstance.
Did you make that argument here, that it was an exception to the rule, or you just argued? I don't remember that argument. Did you state that in your papers? Did you say this was the exception? And
No, I hear you, Your Honor, and I'm trying to...
I'm trying to be clear.
What?
I was trying to be clear.
You were. And I'll try to be clear in response. I don't think we said it, but I'm not sure it's our burden to say it, because the nature of that exception allows the point to be made in the fashion that you and I seem to agree it can be made.
Thank you.
Then go ahead.
So there's a sentence in that provision 6.c. Finally, Nabula must pay any indemnification amount in advance of the final disposition of any such action, proceeding, or claim upon receipt of an undertaking or buyer on behalf of the indemnified party seeking advancement to repay the amount advanced, should it ultimately be determined that the indemnified party was not entitled to be indemnified hereunder under the Act. Why is it just totally unreasonable in an arbitration for the arbitrator to say that the phrase "any such action" that appears in the sentence I just read to you covers not only third-party actions, but also a first-party claim?
Because if you can rely on the so-called rule of last antecedent, which carries you back to the third-party claims, But second,
Well, but the immediately preceding sentence, is it not, any indemnification should only be from Nabula's assets or insurance, and no member or other unit holder shall be required to contribute capital. So the sentence appearing immediately before it does not deal just with third-party claims. And doesn't the whole section deal not only with third-party claims, but couldn't it also be deemed to include first-party claims? So maybe if I was interpreting this, I would reach the same interpretation you put on it, but that's not the test when we're looking at an arbitrator's decision.
any claim for indemnification is based on a third-party claim, and then, and that's not this case. And then the next sentence says, any such claim, and then any such indemnification.
Isn't what follows, any indemnification should only be from Nabula? Isn't that what follows?
I'm sorry, Your Honor.
Isn't any indemnification should only be from Nabula's assets? Isn't that the next following sentence?
It says any such indemnification shall only be from the assets or insurance of the company. And the next sentence says any such indemnity shall be paid by the company in advance of the final disposition. So I would argue that the such...
But it says finally Nabula, I'm sorry to interrupt you, but finally Nabula must pay any indemnification amount. Why does that any indemnification amount relate only to third-party actions that not also include a first-party action?
I'm not sure we're looking at the same any claim for indemnification. I'm looking at 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 lines up from the bottom of the section. I'm at page 96 of the record. Are we in the same place, Justice Friedman?
You're looking at the section that starts, any such indemnification shall be paid by Nabula in advance of the final disposition of any such action, proceeding, or claim upon receipt of an undertaking by or on behalf of the indemnified party. That's what you're looking at.
Well, it doesn't start with that language. It ends with that language.
That's what you're saying. The rule of the last antecedent should be applied to, essentially.
Yes, but if you look at the sentence, 2 sentences prior, if any claim for indemnification is based on a claim by a third party, and then it talks about what has to be done. The next sentence says, any such indemnification. That only can apply to a claim for indemnification against a third-party claim against the company. And the next sentence says, any such indemnification shall be paid by the company. Again, that can only be seen to apply to a third-party claim, not to a first-party claim. And it doesn't make any sense in this case for it to be allowed to apply to a first-party claim. This is a situation where a guy in concert with other rogue actors tries to steal the business of the company. He loses tens of millions of dollars for Nebula's sole client. He makes unauthorized payments to himself of $1.865 million, and he pays other money to other people. He hides the fact of Michael Graves's passing away from the Nebula's bank. He steals Nebula's intellectual property.
Thank you, counsel. I've let you go on over the time, and you will have rebuttal.
Thank you, Your Honor.
May it please the court, Alexandra Avocado for Colin McCarthy.
So I imagine you're going to say that 6.5C advancement relates to the first sentence, not to the third sentence?
That is exactly what we're going to argue, Your Honor. and I'll pull it up here. I guess the threshold point I'd make before diving into the text of this paragraph, which I'm happy to do, is the fact that we are doing such a searching analysis of the text of the paragraph here just shows that this was an issue for the arbitrator and not the court. The law is clear that even an arbitrator's misconstruction of an unambiguous contract is not enough for vacatur. Instead, the arbitrator has to create an entirely new contract for the parties. Clearly, our discussion of these specific words and phrases and clauses is showing that what the arbitrator did is construct the contract. But in any event, we agree that the arbitrator construed it correctly. And so diving into the last antecedent rule, what I'd point out is in the advancement sentence at the end of the paragraph, it says, any such indemnification shall be paid in advance of any such action, proceeding, or claim. Now, as Nebula argues, the word such indicates that you're referring back to something. But the only thing this sentence could be referring to is the first sentence that describes the broad scope of indemnified claims, because that's the only place that the phrase action, proceeding, or claim appears earlier in the paragraph. And of course, there's other textual indicators like the broad use of the word any to signal that the claims that are subject to advancement are first-party claims, not just third-party claims. I'd also point out that it would
You're
make...
fastening on the fact that it says any such and not just such.
I don't think I think that's a point in our favor.
You say you don't need to get to it, but this isn't that what you just said, that you're, as an additional support, that it's not limited just to third party?
I think that's right. I think there's two instances of any such...
Could have just said of such.
Correct, exactly. I think any such indemnification, those three words on its own, broadly capture all indemnified claims. And then later on the next line, any such action, proceeding, or claim, that just makes it crystal clear that they're talking about the first sentence. Also, the fact that we're talking about the last antecedent rule in general, I think just makes the arbitrator's ruling all the more insulated. This is a canon of construction that applies when contractual language is ambiguous. And of course, an arbitrator cannot have exceeded her authority or acted irrationally by interpreting ambiguous contractual language. And I think the forfeiture point that we were talking about a few minutes ago is also relevant to that. As the court noted, Nebula did not raise this last antecedent argument before the arbitrator, and that's relevant not just to ordinary forfeiture principles, but again to the vacatur standard. Nebula has cited no case suggesting that an arbitrator acts totally irrationally by not adopting a discretionary canon of construction that it was never presented. The last point I'll make on the last antecedent rule, since we were talking about that earlier, is that if Nebula is right that you only get advancement for third-party claims, advancement wouldn't do any work. And that's because when you have third-party claims, a party has to allow Nebula to defend and settle those claims. So Nebula is the one incurring attorney's fees and other expenses when you have third-party claims. There's nothing to advance in that situation.
This indemnification clause, the partnership says in this clause here that it will indemnify a unit holder, a limited partner, and hold them harmless, officer trustee, for their acts on behalf of the partnership. Correct?
That's one of three ways that the...
What are the other two ways?
If conduct is taken on behalf of Nebula, in Nebula's interests, or if a claim is by reason of the fact of somebody's corporate employment. So all of those are independent, if perhaps overlapping routes for the indemnification right to be triggered. We believe all three of those apply here.
But in that case, someone is going after the partnership or one of the officers or limited partners or unit holders, correct?
That would be correct. So that would
So
describe...
that sounds like a third-party claim to me, not a first-party claim, which is what counsel is arguing.
I disagree, Your Honor. I think that language...
I'm pretty sure you do, but that's his argument. He's saying the only way we get to indemnify is if somebody sues a unit holder, a limited partner, officer, etc., for their actions on behalf of Nebula.
And there's nothing stopping Nebula from suing one of its members based on actions that that individual.
But that indemnification clause does not come in that case. It would only be triggered, they would be obligated to indemnify when somebody is getting sued for what they did on behalf of Nebula.
That's correct, but the person who is suing can be Nebula itself. There's no limiting language here suggesting, and again, Nebula has conceded that the indemnification right covers first-party claims, not just third-party claims. So I
Where
don't
does
think
it say
that's an
that?
issue here. Where does Nebula say that?
Yeah.
At page 31 of its brief, it recognizes that first-party claims, so claims where Nebula is suing one of its members, are subject to indemnification under this paragraph. Nebula's only dispute is to whether those claims are subject to advancement.
Now, speaking about advancement, in order for a unit holder, partner, officer, et cetera, to be entitled to an advancement, don't they have to put up an undertaking?
Yes, and Mr. McCarthy did. He submitted an undertaking that he would repay any fees that were advanced if it turns out that he was ultimately not entitled.
So how much did he post?
I believe the undertaking was a written undertaking, is my understanding.
Was a written undertaking?
Yes, and Nebula has never argued that the undertaking was insufficient, so I don't believe that's an issue here.
But to just put a point on it, is all of this about the interpretation of this section? All of these questions, or not?
If the court thinks that a de novo review of the arbitrator's interpretation of Section 6.5C is warranted, notwithstanding the high standard for vacatur, then most of it turns on to this. Yes, for Nebula's other arguments, I understand Nebula to have abandoned its Rule 19 argument because it doesn't mention it in its reply brief. Nebula also argues that the employment agreement precludes advancement. Again, that is a bread and butter contract interpretation argument that the merits are for the arbitrator and not for this court, but we also explain in our brief that in any event, the arbitrator correctly interpreted the employment agreement as not being at all relevant to the advancement right in Section 6.5C. I'm happy to talk about that further, but I see my light is on. So if there are any other questions, if there are no questions, we would ask the court affirm.
Thank you.
Look, if Mr. McCarthy brings claims against a company and ultimately he is successful, he is not without a remedy for his legal fees and his costs. And under Section 12.6B of the agreement, which is in the record at page 121, is a prevailing party fees and expenses provision. So it's not as if adopting the result that we seek leaves him bereft in the case he ultimately prevails in the lawsuits, whether his claims against the company or the company's claims against him. I'd like to...
Counsel, can you briefly address why you believe that the award violates public policy or constitutes a manifest disregard of the law? Because I know that was, part of your brief too.
I'll be pleased to, Justice Kennedy. It can't be good public policy to pay a guy whom you have accused of, in the vernacular, but I can think of a no better phrase, ripping you off egregiously, to pursue those claims against you, at least until he's able to demonstrate that you're wrong. Why?
So where does the undertaking come into that argument? Which
I'm sorry, Your Honor.
Where does the undertaking come into that argument, which your colleague says you didn't challenge the sufficiency of the undertaking?
Well, one of the problems, to be blunt, is that it's the agreement provides for an undertaking and not a bond. If this
That's what you negotiated.
Well, I mean, I live with what I'm presented with, and I mean, if the guy's a thief, why is his undertaking, which is merely a signature on a piece of paper saying, yeah, I'll pay you back.
Well, it's not what you'd usually think you'd agree to, but it is what you did. It is what you agreed to. I don't mean
can't-
you, whoever
I'm not
negotiated
gonna
it.
Disagree. May I respond to one last point, Your
What
Honor?
about the manifest disregard on the law? Because I didn't hear that.
Which question were you saying you were going to?
Justice Mendez's
Yes, please do that. Thank you.
But I don't want to ignore Justice Kennedy, so you tell me.
Well,
Thank you.
the one first, and then I'll
I was
see
first.
where I
All right.
don't think he.
So it is not in the interest of the company or on the company's behalf that he stole $1,865,000. And if he did it purportedly as an officer or employee or agent, totally ultra virus any powers that he might have had in that capacity. So, I mean, certainly not an appropriate circumstance in which the company ought to be fronting, and that's the whole point here.
And now the
is
other,
legal
you
fees.
would give just a,
Yeah, and you know what I kind of forgot what Justice Kennedy used.
Manifest disregard of the law. How
The
would
law is that the arbitrator can't rewrite the contract.
and we'll end it on that. Thank you very much. Thank you both.
Thank you for the hearing, Your Honors.
Glowats versus the City of New York.
Please the court, Your Honors. Matt Bryant for the appellant, Law Office of Matt Bryant. The city is not entitled to an alternative affirmance here. It took an expedient position below.
Haven't we already decided this issue?
No, Your Honor, I don't believe
No?
you have. This court has decided that the Article 78 limitations does not apply. What it has not decided is a clean objection consistent with Title VII's holding now, that an employee objections to the use of medicine based on product development from fetal cells, aborted fetal cells. That is a protected statement of faith that an employer may not ignore, that's clearly established under federal law. This court has not been presented with a clean statement of faith.
But here, I think the individual indicated that he was seeking a religious accommodation because he was unable to take the vaccine because it was derived from aborted fetal cells. There was nothing further, no further explanation. He was given an opportunity to explain further or provide further documentation of how his religious tenets conflicted with the vaccine requirement and provided nothing additional.
I would challenge that recitation of the record. This is not a finding of fact, Your Honor. First, my client was an ordained pastor who was ordained before the pandemic.
Okay.
Right? And second, it was denied. That statement alone under Title VII, that I don't want to take this because it's derived from aborted fetal cells. Title VII says that's a protected statement. There's no authority to suggest that city or state human rights law is suddenly more narrow than that. That statement alone is as clear as objecting to a diet because it's not kosher. There's no more burden on the employee than that. That is what's before the court. It's not a scattergun recitation of things that you throw at the wall to see if.
So how do you distinguish our other cases, our prior cases?
I take an ample amount of effort to do so in the brief, but all of those appear to be from people who are throwing things at the wall. One of them, Your Honor, was a vegan who was apparently.
Address Marstella versus City of New York, which is the case I think that was brought up and talked about in the brief. I didn't understand how you distinguish that. Why shouldn't we follow our case law that says that the issue of cooperative dialogue, also in Kohley versus City of New York, another recent case that came down in 2026. I was actually the judge below on that case. I'm familiar with it. Can you just address the case law? Because I didn't see how you distinguished Kohley. If I remember correctly, it was the same argument, and Marstella is the same argument as well. Both cases are on all fours, as far as I can tell.
No, Marstella had a much broader request.
Let's deal with Kohley. Kohley.
Say again?
K OLA versus City of New York. The exact
the
argument
brief?
was made.
Do I not address that in the brief?
Well, regardless, there's a question posed now. Why don't you, on rebuttal, do it? If you have concerns, you can take a look at your brief.
I would urge Your Honor to consider the timing of that decision, right? Because it is now established under Title VII that the statement here alone, there's no distracting statements. We're not talking about a vegan or a Christian Scientist. We're talking about a statement about an abortion-based objection.
Thank you. So why don't you look for the case so you can answer the question?
Thank you.
Bo Malin Mayer for the respondents. So I do think that this claim is indistinguishable here from cases that this court has decided in the past. So like many other applicants in these cases, plaintiff submitted a conclusory request that failed to explain his beliefs or the need for accommodation. And now he tries to put the burden on the city, saying that the city should have done more of a cooperative dialogue, reached out to learn more about the beliefs. But the city told him on the initial form to describe his beliefs, describe the situation requiring accommodation, and in bold and underline, please be specific about that situation. It's the type of process the court has held is sufficient in Marsteller and other cases. Plaintiff didn't explain anything about his beliefs besides the fact that he is Christian, and didn't make any connection between any such beliefs and his desire not to be vaccinated. Subsequently, the city rejected the initial accommodation request for failure to
Counsel,
set forth.
was there a history of denying vaccines in his record?
No, Your Honor.
Isn't that part of the record that would be required to show in order to make out the exception? Or the accommodation, a better way of saying it.
I wouldn't necessarily say required, Your Honor, but it would. It was
One of the indicia.
reasons. It was one of the reasons for the
You're correct.
denial. In this case, in addition to failure to set forth how his religious tenets conflict with the vaccine requirement, and even after that denial, plaintiff didn't submit anything additional to the citywide panel. And so, the court has said that this is sort of the cooperative dialogue that the plaintiff gets here. The city asks him to explain and then asks him, says this isn't enough, we need more, and he still declined to present anything additional. The burden is not on the city in the middle of a global pandemic to chase him down and figure out more about his beliefs. And I do think that the case is indistinguishable from Marsteller, Rissetko, and Lee, in addition to possibly other cases. I'm not as familiar with the one you mentioned. So unless the court has any further questions, we'd ask you to affirm.
Thank you.
Thank you, Your Honors. Your Honor, that case is not in our brief, but from your questioning, Your Honors, this court, your examinations appear to suggest you're prepared to make a finding of fact. This is not a summary judgment motion. This is a 3211 motion. This was a denial. It wasn't an inquiry. There was no instructions provided. He's a Christian. He provided his ordination. There was no back and forth. It was just a denial. There was no mandatory part of the record. The city litigated that it didn't recognize the objection, and we now know, because it told the federal district court, that it did know this was a protected objection. That's the missing element. We didn't get discovery. We didn't get the document from the city that says we know this is a protected statement. They gave it to another court, not ours. There can be no alternative affirmance, we suggest, Your Honor. Thank you.
Thank you both. Island Consolidated versus Graci and Company.
May it please the court, Henry Masha, attorney for Appellant, Graci & Co. Island failed to carry its burden of proof to dismiss Graci's affirmative defenses. All of Graci's affirmative defenses allege that an engagement letter governs the limitation of damages, precondition to suit, and contractual statute of limitations. And Island's whole theory for dismissing the affirmative defenses is that the advice alleged in the complaint is governed by the terms of an email from April 2015, But that
What about
email
the
was not.
continuous doctrine theory. Why don't you speak to the continuous doctrine theory with the statute of limitations
Sure.
and the tolling?
Sure. I mean, the continuous representation doctrine doesn't apply when you have a contractual statute of limitations. And it certainly doesn't have anything to do with a contractual precondition to bringing a lawsuit. And that's what we allege as
It's
our.
your position that it doesn't apply.
Right.
But you were representing this company since, I think, 2010.
Right.
And you continued to represent them through this period to 2015 and into 2020. Is that correct?
I don't believe it was till 2020, but we did continue to represent them for about a decade.
And so during that period, there was this, the advice that was given was incorrect.
That's what the allegation is.
Exactly.
And our affirmative defense is.
And this wasn't discovered until afterwards, many years later, when you were still representing them.
Right. And our agreement.
So my question is, why wouldn't the continuous doctrine theory apply?
Because our affirmative defense is that we have an engagement letter.
Continuous representation doctrine, sorry.
Right. Our affirmative defense is that that doctrine does not apply because we have a contract that sets a statute of limitations, a limitation of damages, and preconditions to suit.
That contract wasn't signed, was it, in
No,
2015?
it wasn't, but an unsigned agreement can be enforceable. That's Court of Appeals case law, and this court has held that.
How do you rely on the statutory statute of limitations? There, the continuous representation doctrine is a problem for you.
The affirmative defense, the agreement that we submitted in the record says that Island has to tell us within a year of the end of services and let us know and give us notice in order to meet that statute of limitations in the contract. And they also have to go to mediation first. So whatever the continuous.
These are all the things that are in the contract
Correct.
that's not signed.
Yes.
Okay.
But an unsigned agreement can be enforceable, and this court has held that an unsigned agreement can raise an issue of fact. Let's not forget the procedural posture here.
Well, given the procedural posture, all of that is a question right now.
That's right.
That will be litigated, or potentially, depending on our decision.
Right, and that's why the lower court should have denied the motion to let the parties litigate this matter. The lower court just made a decision as a matter of law about the scope of the agreement without having a complete record. Remember, we didn't even take party depositions at the time that this motion was made. And I think that was strategic because Island knows that when the depositions come out, it's not going to be good for them.
Now, when we talk about the statute of limitations, we're not talking about that just broadly. We're talking about it with respect to that tax appeal and whatever audit resulted from it.
Right.
And the documents that we have in the record from the Appendix 69 to 74,
That's right.
in essence show that you have continued to represent them through 2021
right.
On that precise appeal.
Okay, and they have 1 year from the end of that representation to give us notice that they're going to bring a suit. And there's no evidence that they did that. And they have to go, and on top of that, they have to go and seek mediation first. And if they don't do that, their claims are waived. That's what the agreement says. And by the way, that agreement is on the exact topic that's in the amended complaint, sales tax advice. That by itself is enough to raise an issue of fact.
That's the 2015 agreement?
Yes. Which is on the same topic. And there's no reason, and the parties had a professional relationship where it would not be uncommon to have a conversation and then give an engagement letter a month later. That's really unremarkable.
Was the sales tax provision in the 2015 agreement new to that provision?
I'm not sure I follow your question.
I mean, was it in previous agreements before 2015?
I don't believe it was, but those agreements are not in the record. All we have is this agreement, and I think it's fair to say that having that same topic that's in the amended complaint is enough to get this case, is just to raise an issue of fact, and let's litigate the issue.
Thank you.
May it please the court, Mike Rayfield on behalf of the island entities. I just want to start by distinguishing between two issues that were decided in your last appeal. One issue is the applicability of the statute of limitations, which gets to the continuous representation doctrine. Graci has not appealed on that issue, which relates to the tax appeal. It relies only on the engagement letters, which is a separate issue, whether the conditions precedent in the engagement letters apply. And this court should affirm the decision below for three independent reasons. One, the letter is unsigned. Two, the letter does not cover the relevant sales tax advice. And three, any ambiguity has to be construed against Graci. So starting with the unsigned aspect, this court's precedents are pretty clear that an unsigned letter is a mere proposal to contract unless there's objective evidence outside the letter.
It's uncontroverted, is it not, that they're letters of engagement for going back to 2009, isn't that so?
There are letters of engagement, and they were all signed, except for the one that Graci is now relying on this appeal from June 2015. And Graci's own evidence showed that a signature was an essential prerequisite to any contract. All of the other letters are signed, and the June 2015 letter specifically says, if you agree with the terms of this letter, please sign and return it to us. That's Appendix 119. It's also signed by two of Graci's principals. But now I'll just turn to the issue that Justice Patel did adopt. The June 2015 letter simply does not apply to the prospective sales tax advice that's at issue in this case. The letter says that Graci will provide advice about, quote, delinquent federal payroll filings for 2013, delinquent New York State payroll filings for 2013 and 2014, and delinquent New York sales tax filings for 2014. As Justice Patel explained, the June 2015 letter simply does not, quote, cover the 2015 prospective sales tax advice that is at the core of the complaint. And there are a few reasons we know that. One is that the letter is cabined to delinquencies alone. It uses that word 3 times, and it then says, quote, we will not provide tax preparation or accounting services under this agreement. It's expressly excluding tax advice beyond remedying delinquencies. Another important reason we know this is that the advice was ongoing for several years, from 2015 until at least 2020, and yet none of the other letters mention sales taxes at all. If Graci was trying to—
You mean the letters previous to 2015?
And the letters post-2015 don't mention anything about sales taxes. As this court—
They don't mention anything about sales tax, but they do mention the possibility of them doing other work. And that if they do other work, it's covered by these provisions absent having another written agreement.
I think you're referring to—
Don't all of the letters of engagement have a provision to that effect?
Right. And
so there is a contemplation that there will be other work. There may be another written agreement, but if there isn't another written agreement, that other work falls within these letters of engagement.
No, I disagree with that. What the provision says is that any additional services you may request that we agree to provide may be the subject of separate written agreements, either in the form of a separate engagement letter or as an amendment to this engagement letter. But then it says, in the absence of any other written communication from us documenting such additional services, our services will be continued to be governed by the terms of this engagement letter. There were numerous written communications between Graci and Island about the relevant sales tax advice, but it is undisputed that there was no mention in those written communications about any condition precedent, and that's the term that the parties are disputing.
Counsel, you mentioned that there is an exception when there's objective evidence. Is that correct?
With respect to the unsigned aspect of the—
We're talking about the unsigned document.
Right.
So isn't it pre-discovery? How did you come forward with evidence that there is no objective evidence to show that? How would they know unless you give them an opportunity to do discovery?
Well, I think, first of all, I just want to make clear that since this appeal was filed, all of the principal depositions have been taken, and no one has said anything that supports Graci's reading. That's not—
This is the record, is it not?
Correct.
Okay, so let's not—
Fair enough, Your Honor.
You could always make a motion for summary judgment. Isn't that correct?
That's right. But I don't think Graci has pointed to any evidence, and this is the key point. I don't think Graci has pointed to any evidence that Island agreed that a condition precedent—
Who has the burden on a motion to dismiss? Is it— I thought that it's that we give all favorable inferences to the non-movement, and you have to come forward with evidence to make out conclusively that it should be, the affirmative defense will be dismissed. Did you make out that burden?
Yes, I mean, our best evidence are the letters themselves. It's the same evidence as Graci's, which are, the letters are contracts. Their meaning presents a legal question for this court. And apart from a single reference in an unsigned letter to a tax delinquencies, the letters don't say anything about sales taxes at all. And we're also relying on the emails, which are attached to which are quoted verbatim in our verified complaint and uncontested by Graci. And I just want to get to one last point, which is, if you think that there's any ambiguity about these letters, any ambiguity has to be construed against Graci because it's the drafter of the agreement. This court has said in numerous cases that when there's ambiguity in a contract, it has to be construed against the drafter. I'll cite the court to 150 AD 3D 581, First Department, 2017. And that makes a ton of sense in this context. In the 5-year period after Graci gave us the sales tax advice, the parties signed 6 separate engagement letters. Graci had every opportunity to cover this advice, but as the court said in the last appeal, the signed letters, as distinct from the unsigned letters, don't mention anything about sales taxes at all. Now, Graci is a sophisticated accounting firm with hundreds of employees. It knows exactly how to avoid liability through carefully tailored engagement letters. Graci didn't cover the relevant advice, and it stuck with the language that it used. It covered only delinquent sales taxes. It didn't say anything about what the issue at the heart of this case, which is that Graci told Island incorrectly that it was eligible for a manufacturing exemption to several sales taxes if an Island entity both manufactured and installed one of its panels in a building. Now, to be clear, I just want to anticipate one point that I know counsel is going to make. Island was applying the sales tax advice both prospectively and retrospectively. As Justice Chan explained in the first opinion on Graci's motion to dismiss, Island was using this advice to pursue credits and or reimbursements of sales taxes paid by Island. But the advice didn't have anything to do with sales taxes that Island failed to pay. Otherwise, Graci would have said, we're going to, in the letter, we're going to advise you about the manufacturing exemption that we think applies to your sales taxes. It didn't. It just talked about delinquencies, and it did so in an unsigned letter that doesn't apply to begin with. So we would ask the court to affirm the Supreme Court's decision.
Thank you.
Well, I think it's telling that counsel said their best evidence are the letters. They didn't submit them in connection with their motion. When they made their motion to dismiss, they didn't submit them. And with regard to the fact that the 2015 engagement letter is unsigned, that issue was raised for the first time on appeal. So that issue is not something this court can review. But in any event, the objective evidence is that we actually gave them the sales tax advice. They don't dispute that. We have a dispute about the scope of the 2015 agreement. That's not something that can be resolved on this record. Island says, oh, the sales tax advice in that engagement letter, that's different from the sales tax advice that's in our complaint. They didn't submit any evidence to support that. There's no way to prove that. Island has a different Graci has a different interpretation. We say that sales tax advice is all one and the same. It was the same issue. It was the manufacturing exemption. That's the whole reason that we were hired in the first place. You can't resolve that factual dispute on this record. And that's because Island didn't meet their burden of proof. With regard to the argument that the 2015 engagement letter is prospective only, again, there is no way that you can prove that on this record. There's nothing. The judge below just credited counsel's arguments about that. But Graci had a completely different version of events. They say that the tax advice in the agreement is exactly the same as the tax advice in the alleged complaint. So let's just litigate the issue. After discovery, we'll have the party depositions. This court won't have to rely on my representation of them or counsel's representation of them, and we'll actually litigate the issue. The proper course here is to let the parties finish discovery so that we can decide the scope of the 2015 agreement. The Supreme Court short-circuited that process, and that's why this court should reverse and deny Island's motion to dismiss the affirmative defenses.
Thank you. Thank you both. Veloso versus Catura Brothers.
Good afternoon, Your Honors. May it please the court. Angelo Spedafino. I'm an attorney from Cullen and Dyckman. Our office represents the defendant appellants, Hunter Roberts Construction Group, and we are entitled to summary judgment for a multitude of reasons. First being that lead abatement work that led to the plaintiff's injury was on a separate project hired by the owner, albeit it was on the same property. It was under a different chain of contracts. Hunter Roberts' separate contract.
So aren't there triable issues of fact here with regard to 241 and 241-6 as to whether the company, HRCG, the construction manager, was responsible for directing or supervising that lead abatement work?
No, Your Honor.
No questions of fact here?
That is our opinion, at least, because...
So we have the construction management agreement, and on the one hand, that says that there was no general contractor on the project, and that under the terms of the construction management agreement, HRCG was the one who was authorized to supervise and direct the subcontractor's work. And it also says that HRCG was authorized to develop and enforce a project security and safety plan. And it also says that HRCG had the power to stop work if an unsafe work practice was observed. So it seems, based on that and that management agreement, that HRCG would be liable under Section 241 and 240 sub 1 and 241 sub 6. Now, I understand there were depositions, and those depositions came up with a lot of, raised a lot of questions about whether or not HRCG did have the responsibility for overseeing the subcontractor, SEMA's lead paint work, and that was plaintiff's employer. But there are a number of factors that also, as I said, suggest that they are liable. So it seems like there are questions here.
Yes, Your Honor. So first, I'd like to address the contract that you just mentioned, the CMA. In this section that you referenced, there is a further section that I won't read the whole thing, but the relevant part says that the construction manager shall not be responsible for the performance of any services in connection with or related to the existence, discovery, or removal of asbestos, asbestos-related materials, or other toxic and hazardous materials, and the owner hereby agrees to retain an expert. Now, I would then address the going to the controlling contract that led to the plaintiff's injury. That contract has no nexus. There's no nexus between the plaintiff and Hunter Roberts. So the controlling contract where the plaintiff was working that ultimately led to his injury started off with the owner, HRPT, a different entity from Hunter Roberts. Yeah. They leased the property to P57. And then P57 entered into a contract with Nova for lead abatement at the premises. And then Nova subcontracted that work to Catura, who had subcontracted that work with SEMA.
That's where I like to go, actually, the P57 Nova contract, because Section 2.2 indicates that Nova shall undertake and complete the work under the direction and supervision of and to the satisfaction of the developer, the engineer, and the construction manager, and that's your client, correct?
Yes, Your Honor. I believe that the section that you're referring to also doesn't necessarily lock in that I believe that it says the plan is to hire Hunter Roberts, but Hunter Roberts is not a party to this contract. Additionally, it was confirmed by multiple witnesses, Gregory Clancy from P57, who said that Hunter Roberts had no involvement with this lead paint abatement work. Todd Grant, Nova's president, testified that Hunter Roberts was not involved with the paint abatement work and was not even licensed to enter this area.
Now, the P57 Nova contract, it also included a scope of work specifications and details for the planned lead abatement on your client's letterhead, right?
Yes, Your Honor, but P57's decision to include documents with our letterhead should not necessarily, it does not bring us into the contract. We never signed that contract.
Oh, I know, but this just goes with the issues of fact, all the issues of fact.
Yes, Your Honor, but I believe any issue of fact that may exist regarding that is confirmed by the fact that Hunter Roberts is not even licensed to be in this area, so they could not possibly have been involved in this work. I see my time is up. If there are no further questions on there, if I have not answered anything, I will save to rebuttal. Thank you, Your Honors.
Good afternoon, Your Honors. May it please the Court. Lisa Como for the plaintiff respondent. As a preliminary matter, we obviously always have to keep in mind that there is a different standard when you're talking about the vicarious liability under Labor Law 240 and 241 versus the type of negligence-based, action-based liability under claims for negligence. So when it comes to 240 and 241, the fact that witnesses testified as to what Hunter Roberts may or may not actually have undertaken to do down the road after the contracts were signed, which is disputed by the testimony.
It doesn't affect whether they fall within 241.
Exactly. So you can't conflate the two things as I think sometimes may be occurring. And very quickly, there's three reasons why, at the very least, questions of fact exist as to whether Hunter Roberts is a responsible party. One, their basic initial contract to act as the construction manager for the Pier 57 job, which it signed with P57, makes it responsible for the entire project. It's responsible basically to build the whole thing, including supervision and means and methods, as we cite in our brief. Number two, even though Hunter Roberts did not directly engage Nova to undertake the lead abatement work, as evidenced by the contents of Nova's contract directly with P57, there's certainly at very least an argument that it's contemplated that that work is being done under the aegis of Hunter Roberts, as further evidenced by the fact that they developed a lead abatement plan for this project. Why would they do that if it wasn't contemplated? They were going to have responsibility for it, at least contractually, if not sort of boots on the ground inside the containment area. Number three is the exception upon which they rely in their contract with Super P57, which talks about hazardous asbestos and things like that. The key word that has to be remembered there is that the paragraph starts with unanticipated. The exclusion is for unanticipated hazardous materials, as in something that's not contemplated originally. You open a wall and there's asbestos, you have to now do something else. I'd like you That's to not what address this is.
The 200 and the common law negligence, since your light is on.
Yes. Admittedly, there was a lot of testimony from the defense side about what Hunter Roberts did or did not do, but we do point to Mr. Walter Lopez's testimony. He was the principal of SEMA Penton, who was actually doing the work, and he, according to him, he may be mistaken, he may not be credible, or he may be, but according to him, someone from the construction manager, which is Hunter Roberts, was actually involved, actually did inspections of the equipment. This case primarily involves a scissor lift.
And control the work?
That they
Were they
performed.
responsible for directing and controlling the work?
He claimed that they were there and that they did inspections of
Is this in the record?
Equipment. Yes, it's, sorry, I'll just turn to that page. Yeah, Mr. Lopez said that they, page 2502, 2550 to 2551, Hunter Roberts' employee directed SEMA's work, inspected it for safety compliance. Hunter Roberts inspected the scissor lifts every day before blasting began and had the authority to take unsafe equipment out of service, and that they installed, and Hunter Roberts installed the lighting in the containment. Those are all disputed, but that was his testimony.
But is that specifically with regard to the work of the plaintiff?
Yes. That's the plaintiff's boss giving this testimony.
Didn't the HRCG construction management agreement explicitly provide that HRCG would not be held responsible for the performance of any services in connection with or related to the existence, discovery, or removal of asbestos, asbestos-related materials, or other toxic or hazardous materials.
That's the unexpected provision. Again, Your Honor, it talks about the unexpected discovery of those conditions. It doesn't talk about what was already planned. As I said before, to me, that's like you open a wall and there's asbestos, you had no idea it was there. They've already planned and hired and have a whole scheme and safety plans in place for the lead abatement work, which is what gave rise to this litigation. If they were to discover something else, that would be different.
Doesn't the record show that HRGC was not even allowed access to the containment area where plaintiff worked?
There's testimony to that effect. However, going back, that doesn't change the fact that they had the overall responsibility under the contract for the performance of all of the work that's taking place on this renovation project. So they may be vicariously responsible for.
That creates 241 liability. It
Yes.
doesn't create Labor Law 200 liability.
No, I agree, but Mr. Lopez, his testimony seems to contradict that because he claims that they did actually physically inspect, because it's not just about being inside the containment. This case is because there's a claim of defective equipment and a problem with lighting. Those were two of the principal factors in the plaintiff's claim. So Mr. Lopez said that Hunter Roberts was responsible for both of those things. There was a malfunctioning scissor lift, and he said that they inspected it every day before blasting began. Again, he may not be believed, he may not be correct, or he may be, but that in our view would be a question of fact. So if there's no further questions, thank you.
I would like to first start on the Mr. Lopez aspect of this. Mr. Lopez, while he testified multiple times about Hunter Roberts, he ultimately said that he assumed it was Hunter Roberts, and I believe it's Briggs versus Morris, where opinion-based assumptions lack probative value. When pressed upon, is this person actually from Hunter Roberts, he was unable to definitively say. Referencing back the light issue, in Nova's contract, it says that they specifically were responsible for the light. And also, Mr. Lopez, when talking about how somebody came and inspected the lifts before, the testimony that's in the record indicates that these lifts were already inside, and as has been established in the record, Hunter Roberts is not entitled or not allowed to even be in there because they don't have the requisite licenses that would allow them to enter the area. Mr. Lopez, as far as 200, I'll conclude briefly. He testified that only he supervised the work, that nobody else did, that he did not authorize anybody else did. I believe there might be some instances where he said Nova was above him, but he said that it was only him that was supervising the work of the plaintiff. If there are no further questions.
He was guessing that HRCG was involved?
I'm sorry, Your Honor, could you repeat that? I apologize.
Didn't Lopez say that he assumed that the safety guy was from HRCG and he was guessing?
Yes, he said, I believe he was asked if he can remember anything about this. He couldn't remember the guy's name beyond the fact that he was maybe an Irish person. He couldn't remember if there was a name tag, no specific logo.
He believed that HRCG was involved with the safety and inspection of the lead paint abatement work, but acknowledged that he was only guessing.
Yes. I have that exact testimony if you'd like me to read it. If not,
Page
I think we have it.
2657.
Yeah. Thank you very much.
Thank you both. Kohley versus Tari. Counsel, you're first, if you would take, yes.
Good afternoon. I'm Pro Se, so I apologize in advance.
Oh, I thought I saw that there was someone on the brief. Okay, so I'll explain to you. I've given you 7 minutes and 2 for rebuttal. In that time, you should tell us the most important points that you wish to make. When you have 2 minutes left, the white light will come on, and when your time is done, the red light will come on. Okay? So why don't you begin?
It is with utmost respect to you, the Appellate Court of the First Division, I bring forth the following facts of this case, which has from its very inception been riddled with cruel and unusual atrocities inflicted upon myself and my children. On August 4th, 2021, I was removed ex parte from my medical office, New York City apartment, and from my 3 children, and was never granted a hearing pursuant to DRL 234 and 252. I was never granted a hearing, and nowhere in the NICEF record is there a hearing of any kind. Brett Ward, Rosemary Rivecchio, and others working for the plaintiffs cite numerous times the presence of a hearing and an order which never occurred in a clear effort to fool this court. There is no order on August 12, 2021. This is the second egregious violation of my basic civil rights because on August 4th, no effort was made to contact me to appear in court prior to the ex parte order. I was present and available in New York City. The United States Supreme Court has held in Stanley versus Illinois that I, the father and primary caretaker for my children, am entitled to a hearing on my fitness prior to my children being removed, and any ex parte orders are not only severely restricted but require them almost immediate post-deprivation hearings within 72 hours due to the simple fact that such orders are ripe for abuse by claimants who may have other interests in mind to alienate innocent children from otherwise innocent parent. The 14th Amendment protects these basic...
Counsel, sorry, you're not counsel, but sir, I have to ask you on that point. I believe you haven't had contact with the children for some years, maybe 3.5 years, I could be wrong, but you were given an opportunity to maintain contact with the children and you opted not to.
So, Your Honor...
That sounds a little different than what you just said.
This is the strategy that Brett Ward uses in every case that he does to financially strangle the other litigant so he cannot afford it. The court order later on said I had to pay $3,000 a week in order to see my children in a supervised manner. I paid for 10 weeks of that until I ran out of money. And in those 10 weeks, my children revealed to the social worker on numerous occasions they were verbally abused by the mother, they were physically abused, they were neglected, they were called profane names, which is all in the record. And the court ignored all these, and never did the court at that time say, hey, maybe the wrong guy is being accused by the actual assailant and the actual person who's doing the abuse. My children were alienated from me without any due process. It's in the court record, and the social worker notes that the mother was verbally abusing them.
Are you saying that the court did not credit the witnesses that you presented and your testimony, and credited the testimony of the other, of the plaintiff and her witnesses?
Saying that the court completely ignored all the social worker notes, completely ignored the NYPD SVU detective Luis Villandia's report that abuse never occurred by me, completely discredited the fact that my child herself, my middle child, told the forensic psychiatrist, mommy beats me, daddy never beat me. I'm saying, and this is all in the record, and I'm stating that.
This was all before the court at the trial?
This between me being removed from my life and my children until the trial. Multiple witnesses came forward, multiple affidavits were sent to the court by saying that they had personally witnessed Gita Kohley physically abusing my children and not me.
Did these individuals come in to testify before the court?
So these individuals were prevented from testifying at the trial. Judge Waterman Marshall at the custody trial did not permit our live-in nannies to testify to say all these allegations are false. Justice Waterman Marshall did not permit the multiple witnesses who knew my children from saying this never happened.
Did the court give a reason for not allowing these witnesses?
Judge Waterman Marshall just said she didn't want to hear from them. The forensic psychiatrist only interviewed 3 out of 25 witnesses in his assessment, which I had to pay $50,000 for. My children have suffered tremendously in 4.5 years, and every time I've tried to access them, I've been denied by financial constraints and justice's orders, which don't let me get access to my children.
When you say financial constraints, what are you referring to?
It cost $3,000 a week to see my children because the order was I had to pay this private company $3,000 for a day to see my children. So I did that for 10 weeks. After 10 weeks, I was facing the choice of having an attorney or file for bankruptcy. I kept the attorney, and 2 months later, I filed for bankruptcy, which was affirmed by Judge Martin Glenn of the bankruptcy court here, that there was no money left, there were no assets left, it wasn't even worth to do a bankruptcy. I still didn't get access to my children despite trying multiple times.
One visit per week was $3,000?
This company charged $300 an hour. So yeah, that was, I mean, I was the primary caretaker for my children, and this is exactly how Brett Ward strangles.
How many hours was the visit?
10 hours, from morning till evening. And in the social worker notes, which I have sent to you, never have my children been afraid of me, never were they not endearing to me. Many times they said they didn't even want to go home, and all of these were ignored by the court. And this is, at the custody trial, as I pointed out, that I was prevented from introducing critical evidence, and I was threatened multiple times by Judge Warren Marshall, when she said, I'm going to discount all of your witnesses, and I did not have an attorney. I believe, according to New York state law, a person in bankruptcy who's in a custody trial is entitled to an attorney, and I was never offered one. This is a violation of Article 18B in the Family Court Act 262. So the custody trial was obviously a disaster. I wasn't allowed to bring evidence. There was a video taken by my eldest child, and she herself states that Geeta Kohley physically beat my middle child. This video and the transcript was suppressed by Judge Warren Marshall. The middle child can be seen crying and herself admits that her mother beat her. This is VEC 1-125, and it was suppressed by Judge Warren Marshall. Numerous times
I
asked to
thought
make a
that
record.
you had agreed that your wife should have been given sole legal and residential custody, and that was in the best interest of the children.
No, I went to a custody trial because I completely disagreed with that, and I had submitted all the documentation to the court in NICEF of what I had asked for and I even wasn't permitted to make a record on the custody trial, April 21st, 2023, page 151, lines 16 to 19. I asked to make a record and was cut off by Judge Warren Marshall and prevented from making a record. A judge denying a defendant from making a record violates constitutional rights to a fair trial and due process. I mean, the fact is, from August 4 till December 1, I was never permitted to enter any hearing or conference. I was kicked out by Judge Sattler every single time.
I think what it was that you didn't dispute the court's determination that where the court awarded your wife sole legal and residential custody, and that was in the child's best interest. But what you argued was that the justice's hostility, bias, and personal disdain against you deprived you of a fair and impartial trial, warranting a reversal of the
Your
custody
Honor, I
order.
never consented to any removal of my children from my possession because I was their primary caretaker. I was taking care of them 78 hours a week by myself and all weekends. I would never, ever have given up my children because I changed my job to be with them as much as possible. So these are all completely false statements, with all the false statements that are replete throughout this record and throughout this trial.
Oh, I'm sorry, I didn't see that your red light was on. So thank you. You'll have 2 minutes.
May it please the court. My name is Brett Ward. I work for Blank Rome, and I'm here representing the respondent, Geeta Kohley. I think there is a line in the decision, in the custody decision, on page 10 of the record, that really summarizes the issues in this case. In referring to Dr. Tari, Judge Warren Marshall stated, he would not and could not admit any of his harmful conduct or take responsibility for his role in the girl's dysregulation and issues. Dr. Tari's inability to take responsibility for his actions in this case is exactly what underlies both decisions. You have a financial decision, which Dr. Tari complains about the findings the court made on the finances And it did so because Dr. Tari never produced any discovery in the entire proceeding. I'm not saying that he left off a few documents or didn't produce a couple of credit card statements. I'm saying he never responded to a discovery demand ever. Okay, when he got an order of partial preclusion upheld by this court that said if you don't give the documents by December 10th, you will not be able to put in evidence, and we were going to determine the evidence that Ms. Kohley puts in as the only evidence we'll consider. He still gave nothing. The only documents we ever received in this case, and upon which we had to build whatever case we could, because there are many marital assets I'm sure my client got none of because we couldn't find them and knew nothing about them. But all those documents we got was when Dr. Tari uploaded them into hearings, which he thought would help himself. And as Your Honor pointed out, there was 3.5 years that Dr. Tari did not avail himself of access with his children. Now, he can say there was a very expensive supervisor that was appointed. Fine. What's in the record is my client and the AFC at the time said, choose your supervisor, and we will consent so this can go forward, because my client knew then that it wasn't good for these children to not have their father play a role in their lives. But he chose not to do that. He chose to never come back with the name of a supervisor and to do this. And he says it was a cost that he could not handle. Well, he hired bankruptcy counsel to file that bankruptcy. And although he said Judge Glenn found in his favor, no, Judge Glenn dismissed the bankruptcy and sanctioned him for filing that bankruptcy. But what he got from that bankruptcy was a 1.5-year stay of the contempt order because he never paid support. Okay? My client may be the appellant in this case, but she's won nothing. Her and the children live a different lifestyle than they did with this anesthesiologist who earned somewhere between $600,000 and $1 million during the marriage, by his admission. They lost their schools. They lost their activities. They lost one of their homes. Okay? What they got from this is not a win. What they got from these decisions is a little bit of peace in their lives. And I'm asking this court to affirm these decisions so they can maintain that, because that's all they received as a matter from this divorce. Does the court have any questions for me? Otherwise, I ask the court to affirm both decisions.
Thank you.
Thank you.
So we just wait for the other counsel.
Good afternoon. If it please the court, Rosemary Ravecchio, the appellate counsel for the three girls. If I may just start off by correcting a representation made in response to Justice's question. The witnesses were not permitted because they were character witnesses, which are impermissible in a custody proceeding, because they were duplicative witnesses, and also because they were unable to address the issues relative to custody and fitness. Also would like to point out that the respondent mother was awarded sole legal and physical custody of the girls because she was found to be the more fit parent. The trial court found that the appellant father was abusive to the respondent and the girls, leaving marks and bruises on both. And that he was also emotionally abusive. ACS was involved and conducted an investigation. While not filing anything in the courts, they did indicate the case. This is all supported by the findings of the forensic expert who classified the appellant as an authoritarian parent, and other ancillary evidence also admitted at trial proved this point. Sadly, the appellant did voluntarily absent himself from the lives of his children for now more than 4 years. He could have sought a more financially...
Counsel, what's the position of the children? You're the attorney for the children. Do they
Yes, I
want
am,
to
Your Honor.
have contact with the father?
At present, they do not. And that is also, as I am aware, I was not the trial attorney, but that was the position that they held during the trial as well. I do need to point out, Your Honor, that...
Not if it's outside of the record, please.
I wanted to point out to a current the current status.
I don't want to, we're not going to do.
That's very well then. Your Honor, I just want to then point out that I have spoken with the children. They do not want to have him in their lives. They feel their lives are better off without him in it. They feel free. They are not being hit. They are not fearful, and they are doing well. These girls are 9, 12, and 14. I request that the court give credence to what their position is going to be. I echo what Mr. Ward has said in that the appellant has failed to take accountability for any of his actions and to demonstrate how it is in the girls' best interest for him to, in fact, be a present part of their lives.
Thank you. Thank you. Now, sir.
Your Honor, sorry. This is exactly what's wrong with the Supreme Court and the First Department. The attorneys collude with each other to go against the unrepresented litigants. This is exactly the suppression. I have detailed it exactly in my papers of how my children said the mother was beating them and not me. How Dr. Pizarro's report said, I am not a threat to anyone. As far as the financial trial, you've read it before yourself. The financial decision was replete with statements which were completely false and impossible to abide by. I showed many times in my papers that I submitted all financial records uploaded to NICEF as they were requested, every record that I had. The fact here is that on August 4, 2021, I was deprived of life, liberty, and property. I was never given an evidentiary hearing. My children were stolen from me. They are now alienated, coached, and manipulated to say whatever they're told to say because for 4.5 years, their father hasn't been there. But if you look at the social worker records from September 2021, they wanted their father. They were not afraid of their father, and they said their father never, ever hit them. These are all false allegations and a way for the Supreme Court of the First Department to protect itself from all the allegations you're seeing from Brett Ward and other attorneys of what they do here. And I have been denied my children have been denied a father, all from completely false allegations. And I just beg you to read what the social worker wrote, read what Dr. Pizarro actually wrote. And amicus brief was sent to you in regards to my case because it's become very popular. The amicus brief stated that exculpatory evidence which is suppressed makes the decision inadmissible, right? And there's many, many, many cases in which this has been upheld in custody battles. And I'm asking, because my children have been neglected and because they have suffered so tremendously, my children were all left back in their grades once they were on the sole custody of the mother, left back. I'm asking for temporary sole custody, a new trial, and a new financial trial, cancellation of all orders.
Thank you very much. Thank you all. Altman versus New York City Department of Education.
May it please the court, my name is Brian Heller. The issue before the court is whether the plaintiff's claim for whistleblower retaliation pursuant to Civil Service Law 75B can be heard in court or must go to union arbitration. This court should follow the Second Department's...
You started arbitration, didn't you?
Well, there was a filing.
There was filing. And does the record reflect why you decided to discontinue that?
Well, what the record doesn't reflect is that the plaintiff's married to an attorney who kept all options open. There was also a filing of a notice of claim to keep the possibility of a court filing open, but there was never any kind of action taken with the grievance, because this isn't a grievance. The allegations in this case aren't about a disciplinary action. They're not about a violation of the collective bargaining agreement. This is about an assistant principal who brought to light that...
You understand what the facts are. It's a retaliation. She feels that she was retaliated because she spoke up about the principal. But the question here is the one that you raised initially, is whether or not this should be handled by arbitration or pursuant to the civil service law.
Right. The actions taken, the adverse actions taken, are not covered by the collective bargaining agreement.
And what happened at the... I know what happened. I read the... But why didn't it continue in the arbitration?
There's no action to take. So some of the actions are only giving her 48 hours to complete her tenure application, not telling her that there was a possibility of a fight in the next morning, assigning an observation that should have been done months earlier, denying her tenure unless she signed a release, and then permitting her to stay only if she accepted demotion to her prior role as guidance counselor. These are not actions that the union can handle. The union's not equipped to deal with the constructive discharge. The civil service law's protections
So
are
you
broader.
mentioned the civil service law. Where does civil service law section 75B3B fit into this?
So the civil service law, B3, has three scenarios. What the city says is that the second scenario compels arbitration. The third scenario says if neither one of the first two apply, you can go to court. The second scenario says that where an employee...
Why doesn't the second scenario cover your situation?
Certainly. For two reasons. First of all, just when we define what the collective bargaining agreement provision at issue is, it's not within the collective bargaining agreement. It's a memorandum of understanding that was entered into between the parties. And the city's argument is that it contains an anti-retaliation provision, and this is what requires arbitration.
The civil service law says you have to go to arbitration. Can the collective bargaining agreement push that aside?
No, but the civil service law says it has to be a violation of the arbitration agreement that ends in binding and final arbitration. And this provision does not do that. This provision says merely that you can't retaliate against somebody. There's no new benefit given to employees based on that. That's just what the law said. It's not like retaliation was acceptable prior to this provision being enacted. Also, it doesn't compel arbitration. It just says that employees can make a complaint. It doesn't mention anything about arbitration. It doesn't provide a mechanism for bringing it. And this provision...
So does that, at the end, is your claim that the civil service law doesn't apply here because the collective bargaining agreement and the memorandum of agreement do not compel arbitration, which results in a final and binding arbitration?
Well, there's three reasons.
That's
one of them, yes, that it's not final and binding. Number two, that this isn't a violation of the collective bargaining agreement, it's a violation of the civil service law that the plaintiffs bring. And number three, this memorandum of understanding was not even in effect at the time of the underlying facts. The memorandum of understanding had expired in January of 2023, and then the protected activity was March, and then she was pushed out in August, and in October, there was an agreement that made it retroactive. But the memorandum of understanding did not exist. It was not in play at the time this occurred. So there's those three issues.
Memorandum of understanding, I thought you just said something about it not covering that.
Well, that as well. So there's three reasons. Number one, it doesn't cover it.
But it was an anti-retaliation provision.
Right, but
and you're saying she's not seeking, wasn't that an wasn't she saying she was retaliated against?
Yes, under the civil service law. But the mere fact that the arbitration, the collective bargaining agreement, says you can't retaliate doesn't necessarily remove
Counsel,
that law.
Isn't it true that the grievance that you had put in essentially stated that it was a violation of the collective bargaining agreement due to the incorporation of the memorandum of agreement, which was retaliation? That's your very filing.
It does say that. It doesn't say that it's not a violation of the law. There's no election of remedies provision. There's no waiver. There's no argument here. Frankly, the city's only argument has been, well, they agreed to go to a grievance, so therefore they can't bring the law. And that's not what the law says. And that would be a new law about waiver that would be judicially constructed outside of the statute. Thank you very much. I'll save any questions for rebuttal.
Good afternoon, Your Honors. May it please the Court. I'm Elizabeth Friedman. I am appearing for the defendant respondent, New York City Department of Education.
So
Your Honor.
Counsel says that in order for Civil Service Law 75B3B to apply, there has to be a collective bargaining agreement which provides for final and binding arbitration. Do you agree with that? And if you do, where does the agreement provide for such final and binding arbitration?
Your Honor,
Is it your contention that the Article 10, Paragraph C of the collective bargaining agreement fits that requirement?
It does, Your Honor. This does come under the collective bargaining agreement. So under Civil Service Law 75B, the provision that applies is 3B, where an employee is subject to a collectively negotiated agreement, and that basically is subject to the...
And which contains a final and binding arbitration provision to resolve alleged violations.
Yes, Your Honor. So there is, it is provided for
So are
in
we in agreement that you have to have that in the collective bargaining agreement for Civil Service Law 75B3B to apply?
Yes, so there is a memorandum of agreement in the record, that's a record page 32, and it does provide that and it modifies the collective bargaining agreement. In that memorandum of agreement, which we would contest plaintiff's argument, that in fact, that was in effect at the time, it's under, subdivision 16, under record on appeal, page 39, the anti-retaliation provision. And it does, the agreement does compel that any allegation of that you were retaliated against does have to go to arbitration under the collective bargaining agreement. The cases are clear interpreting this particular provision. When you look at these documents together, they do provide for final and binding arbitration. It includes, the collective bargaining agreement includes a 3-step mandatory procedure culminating in binding arbitration. That's a page of record on appeal, page 136 to 38. So the agreement defines a grievance as any complaint by a covered employee that any of the agreement's provisions have been violated. The memorandum of agreement between the DOE and the union includes an anti-retaliation provision that categorically prohibits retaliation in this vein. It prohibits the harassment, intimidation, retaliation, and discrimination of any kind because an employee in good faith raises a concern or reports a violation or suspected violation of any rule, law, or regulation. This provision, it's part and parcel of the collective bargaining agreement because the memorandum of agreement modifies the collective bargaining agreement and it applied throughout this relevant period. So, Your Honor, although plaintiff contests—
What takes this as being required to go to arbitration?
Yes, it does require that.
What requires the arbitration? I mean, Section 16 doesn't say anything about arbitration, right?
Well, part of the collective bargaining agreement, Your Honor, requires arbitration, and I can refer.
How do you get back to the collective bargaining agreement from this memorandum of understanding?
I'm sorry, could you
How do
please
you get
repeat?
back? How
How do they connect?
How do they
you get
connect?
back? Yeah, to from the memorandum of understanding to the collective
so the
bargaining agreement.
three-step
And how does that trump the statute?
So, Your Honor, it trumps the statute in the sense that it provides for a 3-step, Article 10 provides for a 3-step grievance procedure to resolve supervisor complaints. So that's Article 10 under the collective bargaining agreement. Under the first step, the supervisor is permitted to submit a written complaint. His or her immediate supervisor.
Article 10 says the proceeding may be initiated by the Council of Supervisors and Administrators filing with the Board and the American Arbitration Associations a notice of arbitration.
Well, it's, Your Honor.
Does that mean mandatory?
It does mean, in this case, Your Honor, it does mean mandatory. The plaintiff can.
It's clear from the statute that the arbitration is mandatory, but what about the collective bargaining agreement makes it mandatory?
Because the plaintiff has the option of bringing a complaint. He or she can bring the complaint, but once she or he does, she is then subject to the provisions of the collective bargaining agreement. And that's at pages 136 and 1.
Option. She has the option of bringing a complaint.
Correct.
But you're saying once she...
Yes, once she does that, then you're...
Once she starts the arbitration?
Well, once you, under the collective bargaining agreement, she's bound by the provisions.
Once you tell anybody, I have this issue, that's, she has to bring a formal complaint, or once she...
It's provided for in the, under the arbitration provisions of the collective bargaining agreement. It is directly covered by that. So what happens is that there are 3 steps.
You can't abandon your arbitration. Had she not done anything with arbitration, she could have gone to court. But once she filed that she's going to arbitrate, she's locked into that and she can't abandon it.
Well, Your Honor,
she
can't go to court unless she exhausts her contractual remedies. And the cases are clear that when you have a collective bargaining agreement that covers the particular grievance or the particular complaint, which is here that she was retaliated against, you are compelled to proceed under the collective bargaining agreement. That is her contractual remedy you have to exhaust before you can go to court. And there's no question here that she failed to exhaust those contractual remedies. She doesn't dispute that.
So the issue is that once there's a collective bargaining agreement, under the memorandum of agreement, she has to go to arbitration.
It has to be, because the memorandum of agreement modifies the collective bargaining agreement. And it was in effect at the time because there was a successor agreement that was in effect in October 2023. It applied
Maybe you said
retroactively.
it, but what
No
is
question.
what is it about the collective bargaining agreement and the memorandum of agreement that says you must go to arbitration?
Because the memorandum of agreement provides, it talks about anti-retaliation, and the collective bargaining agreement
So you mean
provides
you're
that
relying on-
three-step.
You say that it's section 16 of the memorandum of agreement that compels the arbitration? That is the
That's the
provision?
anti-retaliation provision.
Right.
Yes.
That's the provision that forces this to arbitration?
It's actually under the collective bargaining agreement because it modifies the collective bargaining agreement. That would be at pages, the grievance procedure at pages 135.
Which article is that? Which article of the collective bargaining agreement?
It's Article 10 of the collective bargaining agreement, talking about the grievance procedure, pages 135 to 138.
And what language in that specifically binds the person here to have to go through arbitration?
Because it would be under, on page 137, it talks about arbitration, a grievance which has not been resolved at the level
What
of
about
the
that says it
chancellor.
must go to arbitration?
Because-
What words do you point to in Article 10 which says you must go to arbitration?
Well, that's the Article 10, it talks about the three levels, the grievance procedures, and
Right, but
it has,
talking about the fact that you can go to arbitration doesn't mean you have to go to arbitration. So what is there in that provision which says you're locked into arbitration?
so once you basically go to a particular, when you do the procedure, when you file a complaint, basically, it states that you don't have to go to all three levels, but you do, if you want to then take it, you do have to go to arbitration if your complaint is not resolved to your satisfaction.
Article 10 says the proceeding may be initiated by the CSA.
Well, so basically.
It doesn't say that they must.
Well, Your Honor, it's true that plaintiff was permitted to report her concerns about a violation of law, but once she did that, the anti-retaliation provision prohibited retaliation by her supervisors, which she's alleging happened, and to pursue allegations that her supervisors violated that prohibition.
You say once she did that. What says once she did that, she's locked into that?
She was required to grieve the dispute under the collective bargaining agreement.
Where does it say that?
Because it's under the three-step procedure. Your Honor,
I agree with you.
Is the one, you're saying that she's locked in because of the three-step procedure. What language specifically in the three-step procedure says she must go through arbitration and that she cannot?
Part of the memorandum of agreement, Your Honor, which basically modifies the collective bargaining agreement. So I'm looking for the exact language from that.
So the three-step procedure you're talking about is in the MOA?
It's in the collective bargaining
Actually,
agreement. The three-step grievance procedure is Article 10 of the collective bargaining agreement.
But when I read the memorandum of agreement in item 20, general, it says, nothing in this agreement shall constitute a waiver or modification of any provision of any memorandum of agreement, collective bargaining agreement, letter or other agreement or practice between the department and CSA, except as expressly set forth with herein. But it doesn't say how. I mean, what exactly?
Because, Your Honor, because the plaintiff is subject to a collective bargaining agreement, which contains provisions, which it does here, preventing the employer from taking adverse personnel actions or retaliation, and it has been interpreted to provide that it contains a final and binding arbitration provision that has to be exhausted before the plaintiff can go to court. That's been interpreted by the courts, including this one, numerous times. It's exactly covered by the
What case
provision.
do you have that supports that?
Okay, so De Gregorio versus MTA Metro North Railroad, 140 83rd 530. We do cite that in our brief. Your Honor, there are a few other cases as well from this court that talk about that.
These two specific sections?
The sections similar to actually
Not these specific sections.
Your Honor, I'm not sure if it is actually this
Okay,
particular.
so with regard to these specific sections, where in the CBA you were saying there's in the three-step process, It specifically says must.
Well, basically, that's how it's been interpreted once you
So there
file a
is
grievance.
nowhere
You're
it
covered by
says
the,
must.
well, I am not aware of where that is in the collective bargaining agreement, but the way these provisions have been interpreted, they have been interpreted to provide that, in fact, this is the procedure you have to follow. So the Supreme Court looked at this and basically said it would violate, where the alleged retaliatory conduct would violate the collective bargaining agreement, it is subject to the grievance procedure of the collective bargaining agreement, and that the plaintiff must follow that procedure. Your Honor, this court, in a case called Gill versus Department of Education of the City of New York, it's at 146 AD 3rd 688, in 2017, this court found that the grievance filed on behalf of the union was not resolved at the time the petition was filed, so the court properly concluded that she failed to exhaust her available contractual remedies. One other case that was decided by this court is Catura versus Board of Education, 145 AD 2nd 359, First Department 1988, again found that there was an exhaustion requirement that was not met and therefore dismissed the proceeding. There's no question, based on the case law and based on the consistent interpretation of the collective bargaining agreement in conjunction with the memorandum of understanding, that a plaintiff has to exhaust, an employee has to exhaust contractual remedies before proceeding to court. The Supreme Court correctly decided that that did not happen here and correctly dismissed the action.
One final question. Had this memorandum of agreement not contained that retaliation clause, because it's not in the CBA, then are you saying that had it not been in the memorandum of agreement, she could have gone straight to court instead of a grievance?
Your Honor, that would depend. I think that this specifically, the memorandum of agreement specifically provides an anti-retaliation provision. So I'm not sure if there were none, which there was, but if there were none, what her remedies would have been at that point. Thank you, Your Honor.
I just want to address some of the case law that was raised. DiGregorio dealt with, the main issue is whether or not it was proper for the defendants to raise.
Let me ask you, why shouldn't someone say that collective bargaining agreement, Article 10, Paragraph C, is the Civil Service Law 75B3B provision which contains a final and binding arbitration provision to resolve alleged violations. Let me restate that because I know I didn't say it as clearly as I should have. Collective bargaining agreement, Article 10, Paragraph C, is what is discussed by Civil Service Law 75B3B. That's the final and binding arbitration provision that section is talking about. And where it says may, it means must because of Civil Service Law 75B3C. What is the weakness in that statement?
Well, you have to go through a lot of layers to get to that issue in the first place. But the language of the anti-retaliation provision isn't a negotiated term. It's not something that was decided between the parties. It's not like retaliation was okay before this provision.
But you have a collective bargaining agreement which contains a final and binding arbitration agreement.
Right.
And under the Civil Service Law 75B3B, where you have such a provision, you must go to arbitration.
Let's look at
what's wrong with
what it says is that where an employee is subject to a collectively negotiated agreement which contains provisions preventing an employer from taking adverse personnel actions. Now, if the plaintiff was complaining about being suspended or demoted or fired, then that would be a violation of the arbitration agreement. But that's not what this case is about. These are not claims that can be arbitrated.
This is about adverse personnel actions.
But it's not about a violation of the collective bargaining agreement. And the Second Circuit has held that repeatedly in Warmbier in 2025, in Flynn versus New York State Department.
If the memorandum of agreement is part of the collective bargaining agreement, then it is part of the collective bargaining agreement.
It's what it really is an end run around Civil Service Law 75B. It's saying, well, if we say in the memorandum of understanding that you can't retaliate, now they all have to go to arbitration.
To call it an end run, and I understand the argument, but it really seems that Civil Service Law 75B3B looks at these things going to arbitration.
That does, but it also deals with a certain subclass of actions going to arbitration. And it doesn't point, it points to provisions talking about what people's contractual rights are, not statutory rights. You can't put a label, just throw in a statutory right in the collective bargaining agreement, and all of a sudden it's now contractual. She's not seeking a remedy for her contractual rights. And that's the distinction that the Second Department has made. And what the lower court did wrong was basically say, she's in a union, there's a collective bargaining agreement, go to arbitration. And as the court has seen, it's much more nuanced than that. Thank you very much.
Thank you. Thank you both. Ada versus 450 West 31st Street owners.
May it please the court, good afternoon. My name is Peter Zlotnick of Saul Ewing on behalf of Appellant Ada Inc. Without question, the lower court erred in three respects in this action. It dismissed the underlying Yellowstone action with prejudice on the basis of res judicata, in spite of the fact that the underlying action was predicated on new facts, namely new legal process in the form of a notice of default and violation letters.
Your argument is that with the Yellowstone, all the ADA had to do was prove that they could cure.
Correct, Your Honor.
And that was it. It was sort of preserving the status quo. And, well, I mean, that was essentially it for the Yellowstone.
Yes, Your Honor. Justice Reed found below that the sworn affidavit and the verified complaint, which specified that Appellant Ada was ready, willing, and able to cure any defect that was listed in the notice to cure, she was able to do. He made a finding of credibility at a motion to dismiss level on a CPLR 3211 motion. That
But this was about the dock, the loading dock.
Correct.
And the parking lot.
And her
So
right-
it was to be ready, willing, and able to cure meant getting everything out of there.
Correct. And she indicated that
It wasn't about paying money at the time. It was about getting everything out of there.
And there was some confusion, we believe, on the part of the lower court as to which loading dock was actually being cluttered with various furniture and other items and parked cars. And in fact, the cooperative board, after Justice Reed entered his Article 78 order, before this appeal was unanimously, before our appeal unanimously reversed Justice Reed on that action, I'll call it Ada 1, he indicated that she was not entitled to park in the parking areas, that it was a public parking area.
But he didn't know yet at that point. That,
He did not.
So he was mistaken.
Correct.
When he made the determination in this particular matter, because he did not have that decision in his hands yet.
That's correct. And he actually entered a temporary restraining order, finding that the cure period, which was timely filed, we filed the Yellowstone proceeding before the cure period expired, was valid, and that the cure period was told for several months until oral argument was heard.
The pictures that appear at page 605 to 609 of the record, so they reflect a parking area, a loading dock, a fence, and then on the other side of the fence, it looks like there's a car parked, am I right?
That's correct, Your Honor.
So your space is where that car in the back is parked?
Our space was on the right side in that photograph. It was looking towards the cooperatives.
That loading dock that appears in that photo, is that yours?
It depends on which photo you're referring to. Exhibit F, which was in the record, That shows the co-op's loading dock with cars parked with the
And then to
Supra's
the left
Nissan
of it,
Pathfinder.
facing the picture, to the left of it, there's a fence, and then you can go beyond the fence, and obviously you can drive in.
Correct.
And that would be your loading area?
Yes, Your Honor.
So, I mean, in terms of bringing yourself in compliance with the notice of cure, if you just stopped using it, you would be in compliance. You obviously couldn't stay in business if you stopped using it, but if you stopped using it, you would be in compliance.
Yes, Your Honor. And what the super had told us was that the board had required us to schedule deliveries. and
Permission.
Correct. And they changed the locks subsequently. So we made several motions to try and enforce ADA's rights so that they could actually access the deliveries and access the parking area that was demised and that this court found was part of the demised premises of Unit 1B during the prior appeal. So with respect to the Yellowstone injunction, we believe the court just misapprehended both the facts and the law and erred. With respect to res judicata, we believe that that's just a red herring, that that's not a doctrine that should even be applicable here because the notice to cure and the violation letters were new facts. They were subsequent to the court's dismissal order of the Article 78 and required that the court visit anew these new issues. And in fact, we refer in our brief to cases that say that subsequent facts that occur after an order of the lower court are not claim precluded. So in that matter, we believe that not only was the court wrong in finding res judicata, but that when this court reinstated Ms. Ada's claims, that obviated any findings that the court had found that she violated House Rule 21. Since House Rule 21 was found to not be enforceable under the bad faith arguments that we made prior to this court.
Your light is on, so you'll have some rebuttal time.
Thank you, Your Honor.
Good afternoon, Your Honors. Jeffrey
Good afternoon.
for Responding Co-op. Your Honor, there are several misstatements that have been made here that have to be corrected. First of all, we have to look at the timeline here. The Article 78 dismissal was on 12.
Talking about timelines, did this use start in like 1980?
Excuse me?
Did this use start like in 1980?
Well, she claims that she was doing that, but that's not the point, Judge. The point is they brought in Article 78. The first cause of action in the Article 78 said she owned it and she had exclusive rights to the parking and to the loading dock. Justice Reed found that was not the case. She sought injunctive relief for the same basis. That was denied. They sought to disavow several House rules. All those were found to be valid business judgment rule. Now, what happened after that? After that, she ignored the order. What this case is about is somebody blatantly violating an order of the court. I started off my brief by quoting from DeSalvo against Mosso, a famous case where Judge Titone said, if you don't appeal it, it is binding. Now, what happened here? What happened is she ignored it. We tried to resolve it. We sent her a note. We sent her a cease and desist. Ignored it. 2 weeks later, we sent her a notice of cure, and then she brought the Yellowstone. But here's what happened. Here's what happened. The Yellowstone action, and we have to go with that too, because if the action is dismissed, you don't even have to deal with the Yellowstone. If there's no underlying case, you don't even have to deal with the motion. But I'll deal with that as well. Here's what happened here. The order that they're appealing from was entered on June of 24. They did not even bother to appeal the Article 78 until 4 months later. And this court did not reverse. They did not reverse. This court modified to the extent of reinstating a couple of causes of action. Those have not been resolved. That has to be resolved in front of Justice Reed. So as we stand right now, there is no finding that she has the right to do that. And also—
Counsel, what's the point of proceeding with the the other case if you don't have a Yellowstone injunction. It just ends everything. You would just,
well,
the lease would
Judge-
be over.
No, Judge, but see, here's the thing. Here's the thing with the Yellowstone. With the Yellowstone, the last one is to have a willingness to cure. Okay, I get that. Except it's a little bit different here, Judge, because if we had just served them with a notice to cure, the first case didn't happen, let's make believe it didn't happen. Serve them with a notice to cure. They say, hey, I didn't violate this. I want to get my rights resolved. Well, excuse me, they had already been resolved. Judge Reed already found that you could not do
Counsel,
that.
So, counsel, just listen for a second. Maybe you didn't understand my question. The appellate division squarely stated there's an issue of fact as to the allegations with regard to the parking area and found that that's an issue that has to be dealt with Judge Reed. But if you don't have a stay, that issue will be mooted out because, as you know, if you don't have a Yellowstone injunction, there's no cure period. The RPA PL 753 cure is no longer there. Without the Yellowstone, this case is over for the tenant.
Well, it's not over for the tenant because what the tenant did here, Judge, what the tenant did here, she cured. She cured up until the time that there was this modification. And then she found a way to go back to park. So the Yellowstone is irrelevant here. The Yellowstone has nothing to do with the fact that res judicata applies. The first cause of action in the Article 78 is virtually identical to the third cause of action in the complaint. The second one was already resolved that she didn't have the right to park. And again, what I said, in terms with the Yellowstone, Judge, you've got the situation. It didn't come out of the air. That we served the notice.
Can I just go back and ask you a question that PJ had asked earlier? Isn't the burden only to establish the ability to cure? And wasn't there an affidavit from the client stating that they have a willingness to cure? Why shouldn't we adopt a liberal interpretation of the Yellowstone injunction we've done for decades?
Because, Judge, first of all, I don't want to repeat myself, but if you affirm the dismissal of the action on res judicata grounds, which I urge you to do because it's very plain what happened here.
Assume we don't do that.
Okay, well, even assuming that you don't do that, you don't have your normal Yellowstone situation here. You can't say that you're willing to cure when you have a court order that says you cannot do this and you continue to do this.
Thank you. Thank you.
I'll be brief. The timeline that my friend and colleague here has given this court is not accurate. In April 2023, Ms. Atta commenced the Article 78 proceeding. On December 19th of 2023, Justice Reed dismissed the Article 78 from the bench prior to any findings of fact, prior to any evidence being taken, any discovery on a CPLR 3211 motion that my colleague made. On January 16th, 2024, within 30 days, Ms. Atta and the other appellants filed their notice of appeal. Their appeal was timely, notwithstanding what was just discussed. On January 30th, 2024, a little over a month after Justice Reed ruled from the bench, the co-op issued its 30-day notice to cure after we filed our notice of appeal, threatening a forfeiture of Ms. Atta's valuable proprietary leasehold interest and beneficial ownership in the cooperative. On February 23rd, Ms. Atta filed the underlying action seeking the Yellowstone relief. On that same day, Justice Reed entered the TRO, which I referred to earlier, finding that she had meritorious grounds, and the action for the Yellowstone relief has three causes of action. The first sought to toll permanently and on a preliminary basis the cure period in the lease. The second was to show that, or to declare that she had the rights in parking in the area and using the 25-foot perimeter that is the area in contention here. The third had to do with the rights of the parties as to whether Unit 1B included the parking area and the accessory parking. That, we believe, has been substantially resolved, if not completely resolved, by Your Honor's prior decision. So the timing and the chronology is very important. My colleague suggests that we brought this.
I think we understand the arguments. Thank you very much. Thank you both.